Courts of Justice Committee will come to order. Clerk will open the roll.
Two, three, 4, 5, 6, 7. One more.
Close the roll.
Mr. Chair, you have a quorum.
All right, a couple of housekeeping measures we can undertake while we wait for a couple more members to come. Senate Bill 156, Senator Edwards' bill, he's requesting that that be stricken. So Senator Stewart moves, Senator Howell seconds. I suppose that the bill be stricken. All in favor signify by saying aye. Aye. All opposed. That bill is stricken. Senate Bill 904, Senator Peterson's bill, deals with the Line of Duty Act. Those bills traditionally go to the Committee on Finance. Senator Stewart moves, Senator Reeves seconds. Motion to re-refer that bill to the Committee on Finance. All in favor of that motion signify by saying aye. Aye. All opposed. That bill is re-referred. Senate Bill 952, Senator Stewart's bill dealing with protective orders, pursuant to his request and without objection, will go by for the day. So, with that, let me turn the chair over to Senator Stewart. Can I present a quick bill from up here while we wait for a couple more to show up? I've got Senate Bill 524, which is a Judicial Council and Council on District Courts bill that deals with the electronic transfer of case files. Currently, only civil cases that are appealed to circuit court from general district court can be electronically transferred. This bill expands that authorization for electronic transfer of electronic files to all cases, not just civil appeals. So with that, Mr. Chairman, I would move the adoption of that bill. Anybody wish to speak to it?
Any questions of the committee members of the patron? So anyone who'd like to speak for the bill or against the bill? Not, there's a motion to report. Clerk, please open the roll. Just press the button that's lit as you're inclined.
Ayes 9, no 0.
Bill reports.
All right. I've got maybe one more that I can handle quickly while we wait for a couple of people. Mr. Chair.
Senator Obenchain.
Let's do, I've got 525. I know that there may be a member of the committee or two who have a comment on this, but Senate Bill 525 is the authorization of circuit and district court judges. This bill is a recommendation of the Judicial Council and the Committee on District Courts. It amends the maximum number of authorized district and circuit court judges. It is the bill that has been filed following the work of the National Center for State Courts and its 2017 Virginia Judicial Workload Assessment Report. At the beginning of the session, we had a presentation by the center, which is based in Williamsburg, College of William and Mary, and they discussed this and addressed this. I think that we'd all agree that there's no perfect way to determine the appropriate number of judges for a particular circuit or district. However, this is a heck of a lot better than the lack of a system that we had before. It still is not perfect, and we have not authorized all of the judges, but this is an update, and it increases the number of authorized judges to 435. It's an increase of 6 judges from the current authorized number of 429, and this is the result of the caseload study performed by the National Center. It's not done by, it doesn't have input from those of us who may have an axe to grind or a desire to have more judges in our circuit or fewer judges in another circuit. I asked, particularly in light of some of the discussion we had with Senator Deeds last year and some of the concerns about the rural districts and circuits about whether the National Center was taking into account adequately travel time, particularly for those judges who have to travel from one district to another, who may not sit in the same courthouse all the time. And this does, to the extent that they have been able to do that, take that into account. So with that, Mr. Chairman, that is the bill.
And Mr. Chairman,
Senator Deeds.
if I could just address that, I think the imperfect nature of the process is laid bare in this study, which is even less perfect, I would argue, than previously. I just want to, the 25th Circuit is where I live and practice, and I want to give you a heads up. There are 10 courts in the 25th Circuit. We went down, we had 4.5 district court judges. We shared a half judge with the 26th Circuit, and we went down to 4 judges when we lost that one. And then we went down to 3 judges that have to serve 10 courts. And the result of that is not that 3 judges serve 10 courts. The result of that is that we have substitute judges that serve at least 3 of those courts on a full-time basis. That's just not acceptable. In Bath, Highland, and Allegheny, you have a total inconsistent delivery of justice at the general district court level. Now, the inequity in that process is borne out by the increase in the circuit judge load from 4 just a few years ago now to 6. Now, 6 circuit court judges, historically, you had 4 circuit court judges, one of which traveled a circuit from Craig County up to Highland County. And sometimes he even served in Botetourt and Rockbridge and Buena Vista. Now you have 3 general district court judges, 5 juvenile court judges, and 6 circuit court judges. I would suggest that judges that know what they're doing can manipulate the numbers. And that's exactly what's happened in this circuit, to the detriment of the people who are served by the general district court. This is a flawed bill, and it's a flawed process.
Anybody else who has a question of the patron?
And I'm happy to, let me just say in response to the question from Senator Deeds, that I have great sympathy for the 25th, and I know the geographic limitations in that district and circuit, and know the frustration about lack of judicial help on your side of the mountain. And I think that that's something that I hope that can be addressed in coming years. And like I said, it's imperfect, but it's a heck of a lot better. And I'm afraid that if we start messing with this, I think every single one of us is going to have a complaint that deals with our circuit, and we're going to be further off. And maybe we can address some of those needs.
Well, Mr. Chair,
Senator Deeds.
I appreciate that, but in 2016, after we'd gone through the process of going to the Committee on District Courts and proven the case there, we added a 4th General District Court judgeship back to the 25th. We passed legislation in 2016 that made that effective July 1. I'm sorry, we did that in 2016 to make it effective July 1 of 2018, I guess. Now this would override that. We'll be back to 3, which won't be funded, and none of the district court judges that have been appointed will come to Allegheny, Bath, or Highland. We'll have substitute judges there, which this General Assembly will continue to fund through the general budget. The Supreme Court will find money for that. But even now, as I pointed out before, when we have 5 circuit court judges sitting in the 26, we have substitute circuit court judges in Bath, Highland, and Allegheny, and that's just not fair. It's just inconsistent and flawed process.
Thank you, Senator Deeds. I think everybody has an issue about the potential equity of it, but we've found a system that's probably the most fair we can find for all of the judicial districts. And while it's tough for some of us, it probably still is the best system we have. Senator Obenchain, do you have someone who'd like to speak?
General district does have 4.
Yeah, actually, the 25th district does call for 4. It does. Thank you.
Does that help you with the bill, Senator Deeds?
A little bit.
I don't, at least the one copy I've got, is that line 48?
It's, no, it's line 90. Yeah, the first part of the bill is what would be effective until July 1.
Yeah.
I'm sorry. Mr. Chairman, Senator Deeds, what is on the first part of the bill is what's effective until July 1 of 2018. That section is set out twice, and so if you look at line 90, the 25th and the general district has the 4 judges.
I would just ask you, ma'am, if,
Senator Deeds.
I'm sorry, Mr. Chair. If you have 6 circuit court judges, how do you allot that in the 25th? You've taken all the drive out of these judges. They don't have to drive anymore.
Well, the way that the numbers are figured is the same across the board. And so it's a formula that was established looking at the weight of each of the cases and the number of those particular types of filings. As Senator Obenshain stated, there were several items that were taken into consideration that you all asked us to look at, specifically interpreters, use of law clerks, and travel in the rural jurisdictions. And so I think it's probably best fully explained in the report itself, but the formula itself is applied statewide. And so, I mean, it's consistent across the state.
Thank you. All right. Any other questions of the witness?
Mr. Chair,
Senator Peters.
and I discussed this with Senator Obenshain last night, and I took the time, which I appreciate, to go through it with me. But in the 19th Judicial Circuit, the caseload study actually said we should have 12 judges. We currently have 10. This moves us to 11, but I think the number, if I recall correctly, was 12.07 for GDC.
What it recommends is 11 judges, and it looks at the caseload per judge with the recommended number of judges. And with 11 judges, my recollection is that the workload comes out to a 1.1
You're right.
workload for those judges, which is under the threshold for adding a 12th judge. So, you know, in circuits with maybe 2 judges recommended, they're going to be kicked up faster than a circuit with 11 or 12 or 13 or 14 judges that spreads it out among more judges.
Right, Mr. Chair.
Senator Peters.
And I would say, Senator Obenshain, I understand that, and you explained it to me. I would just, again, point out to the committee that it says 12, we get 11, so anyway.
Well, and you're actually picking one up, as I recall.
We are, and I'm going to take credit for it.
Mr. Chairman.
Thank you.
Senator McDougal.
Mr. Chairman,
Senator McDougal.
I think he's picking up that one that I'm losing. But with that, I move to report and re-refer to finance.
Second to that?
Second.
All right. Motion properly seconded to report the bill and re-refer to Senate Finance. Clerk, please open the roll.
Ayes 10, noes 1, abstentions 2.
All right. Bill report, Senator Obenshain.
All right. Got Senator Locke. Senator Locke, you've got Senate Bill 196, I believe.
Yes, thank you, Mr. Chairman. Senate Bill 196 addresses statewide professional standards of conduct, and basically needs to look at how we license police in Virginia. Unlike medical doctors and lawyers, individuals who are certified as qualified to serve as law enforcement officers in the Commonwealth cannot lose their certification for unethical behavior or police malpractice. Someone can violate departmental use of force policies, get fired, and maintain their certificate that allows them to be hired at another law enforcement agency. In Virginia, one can only lose their certificate if they are convicted of a felony or certain misdemeanors or fail to do mandatory training. They cannot lose it for misconduct, even serious misconduct. And so what this bill will do is try to clarify this, the standards. So what this bill does is the bill changes the law to allow a law enforcement person to be decertified by the Commonwealth for serious misconduct as defined by statewide professional standards adopted by the Board of Criminal Justice Services. And that's stated on lines 266 through 265. 265, 266. It authorizes the Department of Criminal Justice Services to develop and the board to adopt statewide professional standards against which the conduct of officers should be judged and appropriate due process procedures. It allows the Board of Criminal Justice Services to initiate decertification proceedings against a certified officer who has engaged in serious misconduct as defined in the statewide professional standards. It gives the board until July 1, 2019 to adopt the standards and makes them effective October 1, 2019, giving plenty of time for a process that engages all affected stakeholders. And basically, the public deserves protection against officers fired for serious misconduct who are now able to get hired in another jurisdiction because they are still certified by the Commonwealth. And that's basically what the bill does.
Anybody have any questions of the patron? Anybody wish to speak in favor of this bill? I think that the chiefs had some issues that they wanted to address. Step on up.
Thank you, Mr. Chairman. I'm Dana Schrotta, Director for the Virginia Association of Chiefs of Police. We oppose this bill, particularly in the way it's constructed. It sets up the Criminal Justice Services Board almost like a statewide citizen review panel, which really will interfere with the Police Officer Bill of Rights and the local grievance standards for police officers. We need to be able to have a policy in place with our local agencies, and they do have conduct policies that allows that chief and sheriff to discipline those officers, to take proper disciplinary action, and to fire them. And the other side of affecting sort of the concern that the patron has is in background checks when other agencies hire, that they should be making thorough background checks when they call the agency that may have hired or fired an individual and make sure that it's someone that they consider to be still a qualified candidate to serve as law enforcement. So we respectfully oppose the way this bill is set up and don't really see a way to fix it.
Mr. Chair.
All right, Senator Peterson.
Dana, I mean, I'm just taking this at face value. It just says adopt statewide professional standards. How would that, how would that prejudice an officer? I mean, you're gonna have standardized.
Well, first of all, we have Mr. Chairman, we have a wide variety of types of agencies in the Commonwealth. So those standards really need to be, while you can have a set of sort of model standards, and we have that already. There's a lot of different organizations and like PERF and IACP that have developed model standards for professional conduct. Almost all of our agencies have something along the lines of conduct on becoming a police officer. We have standards such as the Brady standard that if an officer lies and turns out to be someone who cannot basically testify in court, that becomes an issue for retaining that officer. There's a lot of controls already in place. But you have to consider also that our campus police, for example, institutions of higher learning are subject to a lot of federal laws and regulations that wouldn't apply to municipal officers. So having like a one-size-fits-all set of standards would probably not really reach all the concerns that different agencies have on how they discipline and how they supervise their officers.
Any other questions of the witness or questions of the patron? Senator Edwards.
Mr. Chairman. Basically, as I understand it, it says that the officer is engaged in serious misconduct as defined in statewide professional standards of conduct adopted by the board. That would require, in other words, the board adopting these standards. And why would they be any different or more onerous, say, than any other? I can see why each situation may be a little different, but what's wrong with doing it that way?
And let me help you out with his question, if I may, Mr. Chairman.
Steve, go ahead.
I think Senator Edwards makes the point that the Virginia State Bar and the Medical Board also have this same situation where they discipline misconduct by attorneys or healthcare professionals for serious misconduct. And so I think that's part of his question there. Why not law enforcement as well?
Well, Mr. Chairman, as an attorney myself, I can tell you that I'm licensed, not certified. So the difference is that I can hang my shingle as an independent person without anybody supervising my conduct other than the state bar. So those licensure standards are what hold me as an attorney to standards of conduct that are appropriate for my profession. Law enforcement officers are only law enforcement officers if they're employed by a certified and approved law enforcement agency. There is a supervisory and disciplinary structure in place. We have the Police Officer Bill of Rights, and we have the local grievance procedure that addresses the same sort of conduct, addresses misconduct.
Mr.
Now-
Chairman, the
John, go ahead.
question is, you still have the Bill of Rights, which is a process. This is setting some standards. Isn't that the difference?
Well, I mean, this delegates to the Criminal Justice Services Board the creation of standards. It is not, make no mistake, it is not us. We are not the ones who are setting those standards. I don't know whether we know how those standards will be set by the Criminal Justice Services Board. So, I mean, if you're comfortable making that broad brush delegation, I would suspect that the chiefs are not.
Mr. Chairman, no, we're not. To be honest with you, historically, chiefs and sheriffs are actually more stringent on the behavior of their officers than often citizen review panels are or other kinds of non-law enforcement review panels. I think in this case, the other concern is the bill fails to address whether or not a citizen could go directly to the Criminal Justice Services Board and file a complaint against a law enforcement officer, thereby bypassing any kind of complaint process to the chief or sheriff of that agency. And that involves then taking personnel and internal affairs records out of the hands of the agency.
All right, I think our council has an
Mr.
observation.
Mr. Chairman, I think Dana is absolutely correct that if terminated officers in seeking employment with another agency, if their terminating agency in fact gave the accurate reasons why they were terminated to a hiring agency, there would not be this problem. But what's been reported, I think, obviously to the patron and to others, is that we have agencies that terminate an employer, an officer, and then when they're called for background will refuse to give the details or just give a gloss to it. That's what we understand to be the problem.
Okay.
Mr. Chairman, if I may, not to really pass the buck, but that's not something that our chiefs and sheriffs want to happen. They often find their hands tied by the HR managers in local government, that they can't reveal that information.
All right. All right, anybody else wish to speak in opposition to the bill? All right, Claire, are you here?
Can I speak in favor of it?
Yeah,
Sorry.
step right up,
I'm trying.
real briefly.
Mr. Chairman, members of the committee, sorry I'm required to be in more than one place at one time, as you all are familiar with. Claire Guthrie Gasniaga on behalf of the ACLU of Virginia, and we feel very strongly that this is the right course for the Commonwealth to take. I mean, it would be somewhat ludicrous for you to suggest that the chair of McGuire Woods should decide what the standard is for a lawyer and the professional conduct. I mean, there's a difference between whether they should continue to be employed by the agency and whether they meet a statewide standard of conduct. I think it's high time for people who are being policed to be able to experience policing the same across the Commonwealth when it comes to certain overarching standards. And these two things can fit together very easily. There's nothing in this bill that says that chiefs can't continue to make their own decisions about who's going to be employed in their department and to hire and fire whomever they choose. But it does set up a standard that says that person who the chief may choose to separate, who has engaged in serious misconduct, several use of force violations, or as the example of the Colonial Heights guy, he took video off of a perp's cell phone and converted it to his own use, and he's now being prosecuted. But if he gets found innocent, he can go down the road and show his certificate and get another job. And, you know, one of the problems in today's world, given the market is that because people are so desperate to hire people, somebody who shows up with a legitimate and current certification, some people are never going to look behind that. And secondarily, there's a financial incentive, which is if you hire somebody who has a current certification, that you don't have to pay for training that person or bringing them up to code, if you will. So we think this is a really good idea. We feel strongly this is the right course for the Commonwealth to go. There are many other states that have already gone this route. And like lawyers, doctors, hair braiders, nurses, everybody else that the state certifies or licenses, there's a single statewide standard that applies to everybody about whether, what conduct will allow you to keep that license or what conduct will allow you to lose that license. And it's separate from whether you stay employed by the agency that employs you.
And let me just, thank you very much, Claire. Let me just ask, and I don't see that this says that there's a fiscal impact, but there has to be a fiscal impact for this bill, isn't there? I mean,
I didn't get one.
wouldn't it require, Kristen?
Mr. Chairman, I believe DCJS said that they would need to hire a consultant, and then they would also need to hire somebody to oversee the decertification process.
All right. Well,
Mr. Chairman,
Sir McDougal.
just maybe this was more to Claire than it was to Sarah Lott, but Claire, as we look at these other groups that create these processes, aren't they traditionally a process that the members of the group go through and create? I mean, I know we have a lot of responsibility with DCJS, so I think I'm sympathetic to creating a standard and a system, but I think I have some real concerns about the fact that it's who's creating it, the process, and the appeals process. Because if you're an attorney, you know that there's a standard of professional conduct. Whenever there's a change to that, it's sent to all the members. There's lots of comments that are obtained from that, and then there's a move. So I guess I'm not unsympathetic to the desire to create a standard. I'm just not sure that us saying DCJS do it and we don't retain any oversight or guidance as to the membership or how it's going to be done. And I think it probably concerns me more now that I look at the FIS and see that they're going to hire an outside consultant to do it. That gives me real pause for concern. Is it maybe a better course for us to carry this over for a year, see if there's a way we can put together how that system would look of the individuals making the choice?
Mr. Chairman, members of the
Don't you
committee.
agree?
I would say that my experience of DCJS and their development of model standards and policies that apply is one in which the law enforcement community is heavily involved and engaged, whether it was the standards for drones or the standards for body cams. Those were put together by DCJS with active participation from all parts of law enforcement. And so I would assume that they would follow a similar kind of process. Certainly you could amend either of the two enactment clauses, the number 2 that says develop the standards, and give them specific direction about who should be involved in that process if that's of concern. But my experience of them professionally is that they're very much interested in engaging law enforcement in those activities to the extent that those of us who represent other stakeholders are rarely included.
All right. Bill's before us.
If I may just make one other comment,
Certainly.
Mr. Chairman. This bill has been out there since pre-file, and the first I heard of any opposition was today. And I would have appreciated knowing that prior to today.
Okay. All right. Bill's before us. There's a motion properly seconded to report the bill. It would need to be reported and re-referred to finance. All right, clerk will open the roll.
Ayes 7, noes 8.
All right, bill fails to report.
Thank you.
Thank you. Senator DeStaff.
Mr. Chairman, members of the committee,
199.
here was Senate Bill 199. And I guess the easiest way to explain this one is let me walk you through a couple of stories and give you the backstory. So in Virginia Beach, we have a lot of hotels. Those hotels have swimming pools. A couple of years ago, some of the swimming pools had handicap ramps and the appropriate wheelchairs that go down those ramps. A group out of Miami, Florida, using Google Maps, went and looked at how many of them had the cranes to lift the person up out of a wheelchair and put it in. And every hotel that didn't have a crane that they could identify on that, they filed a lawsuit against. Well, because of our laws here in Virginia, they have legal standing under the ADA. So they filed suit against almost every one of our hotel owners and hotels. And on all the suits, they had, we're either going to take you to court, we have legal standing, they gave examples of how and why in the state of Virginia, or you could write a check for this much and fix the problem. So in Virginia Beach, most of our hotels fixed the problem, wrote a check to this firm to dismiss the lawsuit because they knew that they had standing and they wouldn't win. So fast forward to this past year, we have an organization that has pretty much done the same thing to a bunch of our apartment owners. One of the apartments, they had somebody restripe their parking lot, and they made the handicap spots, I think it was 3 inches too narrow. One of the other ones, after they had it restriped, they had a truck that was left parked in the handicap spot. So they filed suit, and they went to the apartment owner. And in this case, they ended up, the apartment owner hired a firm out of Richmond, spent just over $250,000 on that firm to fight it. And in the end, the firm came back and said, hey, we're going to have to recommend that you settle because we're not going to win this. So they settled for $87,000. Here in Richmond was a condo development that was built. And I believe they were fined just over $600,000. So what this bill does, and it's parroted after House Bill 620 at the federal level, is it lays out what an aggrieved person is, what an architectural barrier is, and says that if the individual has an issue, then they can send a letter in and say, hey, I have an issue with this, and they give the owner of the property 60 days to resolve the issue. And then if the owner solves the issue within that time frame, then they send a letter back saying, hey, we've resolved the issue. Here's what we've done to correct the problem. We've either restriped it or we've fixed whatever the issue is. So that's it with the bill. Now you're going to hear folks, and I've had a lot of folks come up to me who are for it or against it. And the folks who are against it are going to provide stories where certain things have happened, but this bill doesn't correct or hurt that in either way. And as a matter of fact, those are some things that, frankly, the bill doesn't solve those problems, and it won't, and I'm not quite sure how to solve those problems. But that's the bill in a nutshell. The Hotel Motel Association supports it, the Apartment Association supports it. There's going to be folks against it as well today.
All right.
So with that, I'll step aside.
Thank you very much. Let me just, before you step aside and before
question.
we hear from other people, let me try and put a finer point on what the issues are. This is a statute that deals with the state remedies.
Right.
And the state action for essentially the state equivalent of the Americans with Disabilities Act. There is the Americans with Disabilities Act. People could still bring a claim under the Americans with Disabilities Act, could still be entitled to damages under that. This would provide the safe harbor for people who were sued only under the State Disabilities Act. Is that right?
That's correct. And at the federal level, they're addressing it with House Bill 620. Last time I checked, it was scheduled to go to the floor. I'm just not sure when.
Mr. Chair,
All right. Senator Peterson.
I actually looked up the state, I don't really do this type of law, but I looked up the state cause of action. One thing I noticed is under 51.5-46, in order to have a claim, one, you have to be a person with a disability that files a petition. Two, the claim has to be brought within a year of the alleged incident. And three, you have to file written notice within 180 days of the alleged incident. So there's already a written requirement right now on the book, so just for whatever that's worth.
Okay.
Mr. Chairman, but if I may, Senator Peterson, on the cases that have come up on this, there has not been a person that was harmed. It was not filed by a handicapped individual. It was filed by a law firm out of Miami. They didn't even visit, and it was still upheld, and they still wrote big checks. So I wouldn't even call it a drive-by lawsuit. This was a Google lawsuit.
Get Obenshain.
All right, yeah, do that. Let's hear from supporters of the bill.
Thank you, Mr. Chairman. Brian Gordon on behalf of the Virginia Apartment and Management Association and the Apartment and Office Building Association. We'd like to thank the senator for bringing this piece of legislation forward. As he described, our industry has seen a huge spike in the last several years of these types of lawsuits being filed for financial gain, essentially seeking a settlement as opposed to a correction of the alleged violation. We appreciate this bill in that it gives our owners the opportunity to cure a violation and actually get to what we think is most important, which is actually making these properties accessible. So we would ask for your support for the bill. Thank you.
Thank you very much. Next. Anybody else? Anybody wish to speak in opposition to the bill? Step right up.
Good afternoon, Mr. Chairman, members of the committee. I'm Colleen Miller from the Disability Law Center of Virginia. Just first of all, as a point of clarification, the bill does attempt to address federal law as well as state law. And really, with respect to the patron, this is just an incredible attack on the rights of people with disabilities. There's not another group that we would make go through all of these hoops and hurdles before they could actually assert their own rights. So here's how it'll go. Somebody with a disability wants to have access to some place and they encounter a barrier. If they complain to the business owner, but they don't give the specific citation of the law, they don't name every time and place where they've encountered this, they don't spell out what the remedy is, and they don't wait 60 days, they're done. They don't have any kind of remedy unless they give all of those details. It's an incredibly complex notification requirement for your ordinary person with a disability. And the business, if this were in place, the business would really have no reason to comply unless the person gives all of those details, because there's no consequence for ignoring the request to fix something. The other thing is the great irony about this bill is that with all of the notice requirements, the only ones who are going to be able to comply with this and enforce the ADA are the exact firms that irritated the patron in the first place. It's such a complicated notice provision that your ordinary person with a disability is never going to be able to raise a complaint.
Thank you. And I just remind folks that I'm not going to try and hurry you. We have a long docket, and I'm not talking to you. I just want to make sure everybody after you knows that we're going to impose time limits, and there's a clock up there. And you're not only using your time, it's the time of the people behind you, and I'm not running the clock while I'm saying this. So I'll let you all step right up and give you a little bit of latitude here.
Mr. Chairman, this clock will not be accessible to the next speaker.
Yeah, no, I understand. Thank you. That's a point well made. Not lost on us.
Mr. Chairman, members of the committee, good afternoon. My name is Mark Roan, and I am here on behalf of the National Federation of the Blind of Virginia. We are the largest and oldest organization of blind people in the Commonwealth, and we are here in opposition to this bill. Just ask you to just envision this simple thing that's not so hard to envision these days. If you come to an apartment building or a place of business and there's now a touchscreen entry to the building, or even a touchscreen operating system to the elevators that are in that building, that's something that just can be made accessible to those of us that happen to be blind if it has speech output to it. But in many cases today that does not exist. So if you encounter such a situation like that in the building, then you have no way to access that building whatsoever. So, just to think about having to give 60 days notice for someone to correct the situation for you to be able to get back into your apartment or to get to your place of business just seems almost laughable if this wasn't such a serious matter. We just strongly encourage you all to stop this bill from going any further today. We appreciate it.
Thank you. Yes, sir. Step right up.
Mr. Chairman, my name is John Smith. I'm with the Virginia Board for People with Disabilities. We also oppose the bill. We believe the bill would remove some existing incentives for businesses to proactively comply with laws that have been on the books for decades, and present substantial barriers, particularly for pro se litigants who want to enforce their rights before the courts.
Thank you. Appreciate it. Yes, ma'am.
Chairman, my name is Maureen Hollowell, and I'm representing the Virginia Association of Centers for Independent Living. We have worked with the ADA, the Fair Housing Law, and the Virginians with Disabilities Act for over 25 years in collaboration with the business community working towards compliance. This is definitely going to put a chill on those relationships and the ability to work together, and we strongly oppose the bill.
All right, thank you.
Mr. Chairman, Catherine Harrison from the Virginia Department for Aging and Rehabilitative Services, and we are in opposition to the bill as well for many of the reasons previously stated.
Thank you. All right, bill is before us. It's been moved and seconded that the bill be reported. Clerk will open the roll.
Ayes 5, noes 10.
Mr. Chairman, members of the committee, thank you very much.
All right, thank you, and thank you to those who advocated on both sides of that. All right, next bill, we have Senator Black, Sir Serval. Senator Serval. Yes. Senate Bill 74.
Mr. Chairman, I don't know if you want to take care of 613. I've agreed
All right.
to push that to 2019.
I'm sorry? All right, Senator Norman moves, Senator Stewart seconds, 613 go by for the year. All in favor signify by saying aye. Aye. All opposed, 613 is by for the year.
Right.
Going to do 74 next?
Sure. That's probably the longest one.
I'm sorry?
That's probably the longest one, so
Well,
sure.
let's see what we can do about that. Oh, I think we can. All right, Senate Bill 74 is very similar to Senate Bill 275 that was introduced by Senator Barker, distracted driving. This bill came out of the Senate Committee on Transportation. It was reported to the floor and re-referred back to this committee. I would remind this committee that the policy statement we made earlier in the year on Senator Barker's bill was to pass his bill by indefinitely on a 9-5 vote. So with that, if you want to briefly describe the differences and what your bill does that Senator Barker's bill doesn't, that might want to persuade us to take a different direction on this, we'd be grateful.
Thank you, Mr. Chairman. Well, first of all, I think Senator Barker's bill was very different from Senate Bill 74 because Senator Barker's bill had to do with creating an entirely new offense relating to, or framing it up as distracted driving. And I guess he incorporated pieces of the existing texting statute into his legislation to create some kind of a distracted, per se distracted driving type of explanation. This legislation goes at the problem, I think, a little bit differently. First of all, the amateur radio people have been dealt with in it, so they're completely exempt from this legislation, and they're happy as far as I know. But what this bill does is sets the line at when criminal and obviously civil liability then would also attach, or traffic liability, because this, I think Barker was also a Class 1 misdemeanor, mine's only a traffic offense, is that whether the phone is in your hand or not. It basically says that if you're going to use the phone in a car, it has to be in hands-free mode and be used in that fashion. And the idea of why to use that as the line is because that's the line's been drawn, I think, at least a dozen, I want to say maybe 15 or 17 other states now, because it's a much easier line for law enforcement to enforce, and it's a lot easier line for people to understand. And it's just a much more workable way of dealing with this problem that also maximizes safety. If you talk to anyone, every year Senator McDougal and I have the pleasure of speaking to the at the DMV Judicial Safety Conference, and we bring this up, and the judges there are very frustrated by it. Law enforcement is frustrated by it. Right now, it's completely legal in the Commonwealth of Virginia to chase Pokemon while driving, or to order food while driving, or to play Angry Birds while driving.
But if you have a crash while you're doing that, isn't that reckless driving?
It could be if you can figure out what happened, or if somebody could articulate what happened or see what happened.
Mr. Chairman.
Sir Stewart.
But to take that one step further, if you're playing Angry Birds on a smartphone while you're driving, isn't that in fact reckless driving? Because failure to maintain proper control. Because you're not controlling the automobile, you're playing Angry Birds. Why is that not failure to maintain proper control?
Well, I didn't say it wasn't. What I said is it's often hard to prove. And it's...
Senator Sasslaw. Seated 2 seats to my right.
You have to kill the pigs.
No.
Yeah.
I would say ask your grandchildren about that. They'll be happy to explain it to you. What this often results in is it's a real proof problem, and there's an enforceability problem. Police have effectively almost stopped enforcing this law because they can't tell what somebody's doing when they see a phone in somebody's hand. When they can't tell whether somebody's dialing a phone number, ordering food, which is okay, or whatever. And so a lot of law enforcement just they don't even write these tickets up anymore.
All right, let me ask you this. I mean, I think we all get the policy issue, and we're
Okay.
all opposed to distracted driving or reckless driving. All right, so I've got a cell phone. Let me step back. You know, if I'm driving, 90 miles an hour on the interstate, that's certainly reckless driving. But if I have a crash and had been driving 95 a mile before, but I'm driving the speed limit then, the fact that I was driving 95 a few minutes ago is of no effect. So take this to my cell phone. I got a cell phone, and I use it to make a call to my wife, and I put it on speaker. I don't have the voice activated. I don't have it synced to my car, but I make the call looking at it in front of me, and then I put it down on the seat and talk to her, and I'm just talking, and I have a crash. I'm in violation of this, aren't I?
No, because I think at that point, if at the moment the crash happened, that device was being operated in hands-free mode, being used in that manner, as it says on lines 20 and 21, I think is the version you have, I think you'd be okay because it's not in your hand and you're using it in hands-free mode.
Okay. All right.
But I also think this would cause people to start using Bluetooth earsets or earbuds or wired headsets or use the Bluetooth in their car. People, I think, would, if we pass this, would start making more accommodations to use it.
And I'll tell you, and I mean, you and I have had this discussion before. My big concern about a bill like this is, we pass bills all the time that are laudable in terms of their goal. But I'm telling you, we pass this will be the most violated law in the Commonwealth of Virginia. There's nobody who will not violate this law. Nobody.
Do you want me to respond? Or?
Sure.
I mean, what I would say to that is that right now, this problem is an epidemic. I mean, you just talk to any of your constituents and they're driving in traffic and they look at the car next to them, everybody's got their phone in their hand. And when Virginia Tech looked at this, they said the average text message takes your eyes off the road for 4 seconds, and at 88 miles an hour, that's the length of a football field. You're basically driving with your eyes closed. And that's why accidents and deaths in this country are up over the last 2 years for the first time in 50 years. And so it's clear this behavior is very dangerous. It's causing accidents. It's killing people. And I think the longer we don't do anything, you're going to have a longer and longer line of people whose children have been killed standing here in this committee asking us to do something.
Which maybe mitigates in favor of the the misdemeanor.
Mr. Chairman, my original legislation last year had a misdemeanor. The chairman of the Transportation Committee didn't like the misdemeanor, so I took out the misdemeanor and made it a regular traffic offense.
All right. All right. Anybody on the committee have any questions? Anybody wish to speak in favor of the bill? Step right up.
Mr. Chairman, Bud Vi from the Richmond Area Bicycling Association. We've got about 1,100 members here in this area. We're used to seeing everybody around us in the motor vehicles with the phones right up here on their ear. They're not normally setting them down on their seat, I don't think, because we can see them. It is an epidemic. We've lost more in the last 2 years. Now we're having bicycle fatalities on the upswing after being on the downswing for several years. And we were pleased with that. Any is too many, but this is a problem, and we strongly support this bill and would like to see something done to try and get it out of people's hands. We all have phones ourselves, and we all drive cars also, and some of us use the phone also while we're driving, but making it into law, I think, will cut out some of the people from doing it, at least. Thank you very much.
Thank you for being here. Appreciate your advocacy. Yes, sir.
Mr. Chairman, members of the committee, Elliot Buckner for the Virginia Trial Lawyers Association, just standing in support of the bill.
Thank you. Yes, ma'am. Step right up.
Thank you, Mr. Chairman and members of the committee. My name is Joy Rowley, and I'm a resident of Herndon, Virginia. Before my 19-year-old son, Kyle, was killed 6 years ago, I never imagined I would become an advocate for safer transportation. Since then, I've met so many who have lost, been maimed, or continue to suffer the impacts of distracted driving, including parents who have difficulty making it through the day every day, even 10 years later. My son was killed by a texting driver in 2011. His killer's phone was confiscated and had 20 texts leading up to the time of the accident, yet he walked away without even a $25 traffic fine. The accident was so horrific, to this day I can't stomach reading the accident report. There were no breaking skid marks. My son was killed as he attempted to move his disabled car off the road with his emergency flashers on. Fast forward 6 years later with improved technology, and we are still stuck with a law that hasn't kept pace with the times. Bluetooth technology is 20 years old in 2018. Our phones talk to us and tell us where to go. We talk to our phones. Simply put, there is no longer a need for us to hold a phone to our ear. Everyone knows it distracts from our concentration, our ability to clearly see the road, and our mobility as a driver. Our own Virginia Tech Transportation Safety Institute has provided so much data indicating, as Scott just said, sending one text is like driving blindfolded through the length of a football field. Having that phone in your hand is an addiction, even with a no texting law. Our neighbors in Maryland, D.C., Delaware, and West Virginia already have hands-free laws. This has been shown to reduce fatalities by 30 to 60%. So I ask you to please support this bill. Thank you.
We're certainly sorry for your loss, and really thank you for your advocacy. Thank you for being here.
Thank you.
Mr. Chairman, Dana Schroeder for the police chiefs. We support this legislation. It does actually put our law enforcement officers in a position where they don't have to subpoena cell phone records to prove that someone was texting.
All right, thank you, Dana. Yes, ma'am. Step up.
Yes, Mr. Chairman. Janet Brooking with DriveSmart Virginia. We stand in strong support of this measure. Thank you.
Yes, ma'am.
Good afternoon, Kelly Sealing from Geico. We stand in support of this measure. And also, I did want to mention, in addition to the lives that it impacts all of you guys' insurance rates too, because as Senator Saravel was saying earlier, frequency and severity in accidents is up. And so that impacts us all.
Thank you. Yes, sir.
Mr. Chairman, members of the committee, Champ Early, President of the Virginia Bicycling Federation, we strongly support this bill. Thank you.
Mr. Chairman, members of the committee, Patrick Cushing with Williams Mullen on behalf of the AAA clubs in Virginia, and we support this bill.
Thank you.
Thank you.
Yes, ma'am.
Hi, Grace Dugan, VCU student. I think it's just quickly really important to say as a young college student to voice my opinion. Just the other day, I was on the side of the road outside my dorm room. I saw someone driving in the intersection where there's a one-way street, had their phone in their hand. They drove up onto the curb on the one-way road going the wrong direction, almost hit like 3 pedestrians. I just think it's really important to pass this bill and help keep the young and old people safe. Everyone,
Thank you.
know.
Appreciate it. All right. Bills before us.
Mr. Chair,
Sir Peterson.
let me ask the patron a question. And we've had these bills pretty much since we've been here, certainly Scott, since you've been here. I think as was mentioned by the chair, once you pass a law like this, basically everybody becomes a potential offender. And there's going to be a huge issue of selective prosecution. In other words, who's going to get pulled over, who's not going to get pulled, because this will be a primary offense, correct?
It's already a primary offense, yes.
Right, so it will remain a primary offense, but we'll expand the scope. How do you have safeguards so that it's not selectively prosecuted, so that it's prosecuted in an even-handed way that people can have trust in this law?
Well, I mean, I think your question sort of goes more to law enforcement generally as opposed to this specific statute. I mean, there's lots of things you can be stopped for now that can be, in theory, selectively enforced. I mean, virtually anything, whether speeding, which probably most officers don't even stop a car until they're probably 10 miles an hour over the speed limit, to things like stop signs and turn signals. I mean, so I'm not sure that selective enforcement on this statute necessarily cuts one way or the other. I would tell the gentleman that right now, you can be stopped for having your phone in your hand if you're doing something completely legally. And so this at least makes that line clearer so that somebody knows that their phone isn't in their hand, they can't be stopped when they're doing something legal. So I think, if anything, drawing that line probably reduces the risk of selective enforcement for legal behavior versus illegal behavior, but that's kind of how I look at it.
All right. Bills before us.
Move to report.
Is there a second? Second. Been moved and seconded. The bill be reported. Clerk will open the roll. You want to strike the board? Strike the board. Clerk will open the roll.
To report.
Right. To report.
Ayes 4, nays 11.
All right. Thank you very much. And it's an issue. And I think we all recognize that. And we need to continue to try and think about ways to address it. You've got Senate Bill 535.
Sorry, which one?
Oh, that's my bill. You want to do that? All right. 607.
Another kind of biggish issue. So this legislation has to do with the problem of sexting. And I'll walk the committee through the bill very briefly. Basically what it does is it makes consensual, the sending of consensual sexting, that is naked pictures of children consensually between minors, a misdemeanor instead of a felony. Section A has to do with transmitting your own image. Section B has to do with possessing 10 images or less. And the reason I picked 10 was when I tried this bill once before, there was a concern about some juvenile having a stockpile or a big archive or library, and so we thought 10 would be a way to avoid that situation. Subsection C creates a SIS education program where charge can be dismissed after education and therapy, and D has to do with venue, to just explain where the offense can be brought. But that's what the legislation is technically. Now, in terms of the backup for this, I went to a conference on this about 3 years ago after I put in a bill, and I got a lot of questions about it. Children's brains obviously are not fully developed, and they develop asymmetrically. So children to put it simply, have one part of their brain related to reproductive issues that turns on faster than the part of their brain that tells them, hold on and stop, don't do that. And so they tend to not be as restrained as they should be when it comes to sending messages like this to each other. When this has been researched, there's 28% of teenagers say they have sent a sext message. It also is a significant indicator of sexual activity, and so frequently it's an opportunity to intervene and have conversations when it's discovered. 76% of kids who've sent a text message are sexually active. Girls are asked to do it a lot more than boys are. 68% of girls say they've been asked, 42% of boys say they have been. The peak age when this happens is 16 to 17, it declines after age 18. There's an article in The Atlantic, a very long article in The Atlantic, that I'm not sure if folks have read, but it featured Louisa County. And it talked about how in Louisa County, when a law enforcement officer became aware of this, he started researching it and he found out that nearly every child in the school had images on their phones. And he was in a real quandary about what to do about it because he didn't want to turn every child into a child pornographer or a felon. And so he couldn't figure out whether to charge or not. And so the current situation right now, it creates lots of problems because when school administrators, teachers, clergy, whoever comes across this and find out it's on someone's phone, there's a felony situation that's immediately arises. And so they feel the need that they have to call in law enforcement, immediately report it, et cetera, when this is really behavior that a lot of children engage in that I think is more appropriately dealt with without law enforcement. It's more appropriately dealt with if you're only talking like less than 10 images or something, that it's really something that you get, parents, counselors, administrators, and medical professionals involved in, instead of having to call on law enforcement to either give a thumbs up or thumbs down every single time it happens because it's a felony. So I think 20 states have now adopted legislation that have a carve out for consensual messages sent by and to and from children. I think that the Commonwealth ought to do the same thing, and that's what this is designed to do. It's designed to encourage intervention and not punishment.
All right. Senator Sasslaw.
When this happens, what's the usual punishment right now? I don't think, Mr. Chairman, I would say to the senator that I don't think it gets charged a lot, but Commonwealth attorneys and police have to get called a lot, and Commonwealth attorneys have to get called a lot to make charging decisions a lot, but it usually just doesn't end up getting charged. So you get a lot of system resources sucked into having to deal with it and make judgment calls on it. Mr. Benjamin might have opinions about that too. So.
Mr. Chairman, Senator Sasslaw, the prosecutors retain the discretion to charge or not. If they want to charge for misconduct, then the concerns become whether the individual, the juvenile, is charged with an offense that requires registration or whether they're charged with something that has a mandatory term of imprisonment. And so the compromise in situations where a juvenile is charged would be something like possession of obscene material, which is still a felony.
Mr. Chairman.
Mr. Chairman. All right, Senator Reeves.
Senator Serval, in the case that this was discovered at a school, would they not have to report it under the current guidelines? And the school would have to report it to law enforcement, and there'd be a report regardless. So if we change it to a misdemeanor, if we can fix the one section of the code, then they could keep that internal and work within the school system as well, correct?
I think that's right. I mean, that's at least my intent, is to try and reduce the need to involve so many people in something that really shouldn't be a felony.
Thank you.
Where's it say felony? Where's it say felony? Mr. Chairman, isn't this a misdemeanor?
Mr. Chairman.
Class two misdemeanor?
Senator Edwards, then Senator McDougal.
I don't see the felony in it. It's a class two.
John, could you speak into your microphone?
It's a class two misdemeanor, isn't it?
Right now, it's a felony. This seeks to make it a Class 2 misdemeanor, which is why it doesn't have a fiscal impact.
All right, Senator McDougal.
Mr. Chairman, I think the situation that Senator Serval describes is one that, as policymakers, we're probably all concerned about. We want to make sure that our criminal justice system is one where we're prosecuting people that are engaging behavior that puts our children or communities at risk. A couple questions that I have about this, and maybe you might have somebody that could tag in behind you to help. Number one is, would maybe this be more appropriate to be under the current child pornography statute as a lesser included offense as opposed to a new section, number one? And then number two, I'm trying to think through, do all the mental gymnastics here to make sure we don't mess up anything in the child pornography statute, because I don't want somebody who is a really bad actor getting an image that's originally created through one of these consensual encounters and then distribute that more pervasively and not be able to prosecute them as aggressively as we'd like to. So those are the kind of two questions. Wouldn't this be better as a lesser included, and are we going to do anything to harm the getting after the bad people we want to make sure we get?
I think Mr. Benjamin's itching to answer question number one. I can probably deal with number two better, but okay. But I don't care where it goes, and I think it'd be fine under there. Although I haven't gone and matched up the terms to see if the terms, the way it's structured, would technically make it a lesser included or not. Whether all the elements are there, because the way lesser includeds work. But I will say, with respect to number two, to the senator, that if this only covers the person originally sending the image or the person in receipt of it, and so if some adult were to get possession of an image later, that would still be a felony under this. So I don't think, in terms of child, some adult child pornographer having it, that it would create a problem there. And as I said when I explained the bill at the beginning, one of the concerns that arose the last time I put this bill in was that there have been situations where there have been children who have like an archive in their house of like 500 images they've captured from other kids in the school, and they put it on a server and make it available. That's why I put the 10 image limit on here, to say that if somebody has in possession more than 10 images, it still stays a felony.
All right. Let's hear from maybe the Commonwealth Attorneys Association.
Mr. Chairman, Mike Doucette, Executive Director of the Virginia Association of Commonwealth Attorneys, and we generally support this concept. We've generally been doing this for a number of years. Sexting is an issue, and it's a conundrum as far as do we want to saddle someone with some serious felony convictions that require registration on the sex offender registry. And so we support, generally support the concept of this particular bill. Senator Stanley has a particular bill, SB 168, and the primary difference between this one and 168 is at the end of 168 there's a provision that says the provisions of this section shall not preclude a prosecution under any other statute. And the reason for that is we've been trying to fashion a sexting statute for years and years, and one of the problems we run into is we know who we want to get, but we don't know how to avoid getting those that we don't want to get. And to address Senator McDougal's second comment, about dealing with particularly bad actors. This works great. This bill works great if we're dealing with somebody who's 16, who's sending it to somebody who's 16 or 15. But what if you have somebody under subsection A who is 17 and a half sending it to a 5-year-old girl, or in subsection B, has a 17-year-old has possession of 9 pictures of a 5-year-old girl. We don't want to. There's a line there that we need to be drawing, and so. Senator Stanley in his particular bill had that allows us that discretion to exercise and saying this is child porn, this is sexting, but again, we generally support the concept that Senator Surville is raising here. We just ask for that added language that would give us that discretion to decide the difference between child porn and sexting.
So why don't we, in order to move this forward, I think this is an issue that I'd like to advance the ball on. Why don't we pass this by for the day, take it up along with Senator Stanley's bill on Monday, And we can deal with both of them then and perhaps
lesser included, too.
merge the concepts. How about that? All right.
That's
So
fine.
without objection, we're going to pass Senate Bill 607 by for the day. Thank you. And anybody, before we do, if anybody came who specifically wanted to speak to it today, for whom it's going to be a hardship on Monday, step up and be more than happy to hear from you.
Actually, Senator, thank you. Valerie LaRue from Virginia Poverty Law Center. I was actually going to suggest what the chair just suggested doing. So.
All right. Thank you. Appreciate that. Let's go to 616.
Thank you, Mr. Chairman. I have an amendment on 616, a line amendment.
Mr. Chairman, on line 15, after Virginia law, strike including sovereign, charitable, and statutory, and insert other than sovereign. So it would read, any theory of immunity granted under Virginia law other than sovereign immunity.
Okay. All right. Senator Stewart moves and Senator Lucas seconds the adoption of that line amendment. All in favor signify by saying aye. All opposed, that line amendment's adopted. Tell us about what your bill does.
Mr. Chairman, this bill basically says that if you have insurance, you can't claim, that covers something, you can't claim immunity. And I carved out sovereign immunity, had some talks with VML, and there's a lot of complexities to that. There is a wrinkle on sovereign immunity, which I don't know if we're going to be able to deal with or not through this process if the bill advances, but basically, we have lots of immunities that exist. We have charitable immunity at common law that is still out there. Most states have repealed it. Either courts have repealed it or they've done it statutorily. We have other immunities that are on the books. And from my perspective, if you have insurance or if somebody has insurance to cover a problem, then immunity ought not to apply. And that's basically what the bill does.
I see your supporters lining up behind you.
Yeah.
All right. Anybody have any questions for the patron? And I would point out that we have a similar, and maybe some of the folks who want to speak for or against this could address the similar provision dealing with school buses and insurance for those. I know that there's a similar provision that if there's a liability policy for a school bus and somebody's injured in that kind of a crash, there is liability for that. So with that, anybody have any questions of the patron? Hearing none, let's hear from anybody who wishes to speak in support of this bill. In opposition to this bill.
The fix isn't good enough. Mr. Chairman, Roger Wiley, speaking for the local government organizations, VML and VACO. We do oppose this bill. Sovereign immunity is a very complex thing. It applies differently in different situations. Cities have it for some functions and not others. Counties have it for all county functions, but not for things like federal constitutional torts. There are then different rules that apply to the public employees than the ones that apply to the entities themselves. There are concepts like qualified immunity and the distinctions based on whether the employee is performing a discretionary act or a ministerial one. All of this is extremely complicated, and if you want to do something to change sovereign immunity, there's a right way and a wrong way to do it, and this is the wrong way. It's way too sweeping. I understand if you take the word sovereign immunity out some way, that maybe you solve part of the problem. I'm not sure you solve it for those constitutional torts. I'm not sure that you solve it for the employees who have qualified immunity for discretionary functions. Right. So we do oppose the bill.
Thank you.
Mr. Chairman.
Sir Edwards.
Mr. Chairman, but taking sovereign out solves your problem, though.
No,
No,
it does not.
You said, Mr. Chairman,
it solves a part of the problem.
There's a right way and a wrong way. What's the right way?
Well, I'm not advocating that we abolish sovereign immunity, but you need to look at the whole big picture. You've abolished sovereign immunity partly for the Commonwealth through the Tort Claims Act. That's one way to approach it. There are others. The other thing I would say about this bill is it doesn't really address how you determine who has insurance coverage and who doesn't. All local governments are essentially self-insured one way or another. They either have their own funds that they set aside for self-insurance, or they belong to one of the risk pools that VML and VACO maintain for them. So it's not like this is shifting the burden of these verdicts or judgments to Allstate or some commercial insurer that's has a huge risk pool that's nationwide or international. All this is shifting the cost back to the localities directly because they pay it through their premiums to the pools.
Thank you. Yes, sir.
Good afternoon, Mr. Chairman, members of the committee. Chris Legault on behalf of PCI Nationwide, Chubb, and AIG. I just want to point out one thing. To the extent that a charitable organization has any insurance, it no doubt was priced in anticipation that the immunity defense was going to take care of any indemnity claim. If you pass something like this, all those charitable organizations out there who had some sort of a policy, they're going to see a spike in their premiums that will be scary.
Thank you.
Thank you.
Yes, sir. We're out of time.
Thank you, Mr. Chairman. Very quickly, John Hurd on behalf of Metis Holdings, which is the company that oversees the administration of all the liability claims against VACO's risk pool. For the reasons previously articulated, we oppose the bill.
All right. Thank you. Yes, ma'am.
Good afternoon, Kelly Sealing, Geico. We oppose the bill.
All right. Thank you. All right. The bill's before us.
Move report. Move report.
All right. If we were to report, there has been a request that it go to the Committee on Finance. There's a motion properly seconded to report the bill. Clerk will open the roll.
Ayes
Close.
2, noes 13.
All right. Next bill, 617.
Thank you, Mr. Chairman. Senate Bill 617 is a statute of limitations tolling bill. I'm carrying this with Delegate Habib, who's on the other side. This bill is a extension of a policy that the committee adopted last year with regard to medical devices. Last year, I think it was last year, this commit, or the, was it last year or the year before?
It was last year.
Yeah, the Senate, or the legislature, created a tolling provision for people who are injured but don't discover and can't reasonably discover they've been injured by a product or by a device, a medical device, until after the statute of limitations runs. This extends that policy to toxic substances or medications. Basically the choice that's between, I mean, right now, we of course say that you can sue a company or a person who injures you when you discover it immediately, but right now, if somebody kills you slowly over a long period of time, you're often left with no remedy, or killed or injured, I should say. And it's really, I think the policy of allowing people to sue after they reasonably discovered they've been injured was something we adopted last year, and I think it should be extended to not only products or medical devices, but also to medications, which cause many people injuries or death over a long period of time. So I just think it's a policy that ought to be extended beyond where we did in 2016.
All right. Anybody have any questions of the patron? Anybody wish to speak in favor of this bill?
Mr. Chairman, again, Elliot Buckner for the Virginia Trial Lawyers Association in support of this bill.
All right.
Thank you.
Anybody else? Anybody wish to speak in opposition to the bill?
Good afternoon, Mr. Chairman. I'm Ann Lee Kerr. I represent PhRMA, which is the trade association for the brand name drugs and the biotech drugs. Spoke with Senator Surville about this a little bit about this yesterday. Where we disagree is that the litigation against a manufacturer of pharmaceuticals is, to me, very complex. You have a lot of mitigating factors that affect you when you take a drug. You know, what is your illness? What are your other illnesses? What is your overall health like? What other medications you're taking? Are any of those contraindicated? And it sort of goes on. Are you seeking care? And those things, with the passage of time, can impair a manufacturer's ability to adequately defend ourselves or really come to the root of what the problem is. So we are opposed to this bill because of the potential for the lost evidence or what we may not be able to tie this to what the injury is. And for those reasons, we oppose the bill.
All right, thank you very much. Yes, sir.
Good afternoon, Mr. Chairman, members of the committee. Scott Johnson. I'm here representing the Virginia Biotech Association, which is the association located right across the street that has members across the state as far as drug research and development. And I also represent the Consumer Health Products Association, and those are the individuals that represent the over-counter drugs. We are opposed to this legislation primarily from a point of economic development. When researchers look where to base clinical research projects, where businesses look to start a new generic company, we base it where it's a good tort environment. We've got a good tort environment in Virginia, and this is a key factor that they look at. We like to keep our good tort environment. We'd ask you to not advance the bill. Thank you.
You very much. Yes, sir.
Mr. Chairman, members of the committee, Jeff Palmer with Reed Smith on behalf of the Virginia Chamber Institute for Legal and Regulatory Reform. For the reasons articulated before and for the increased cost of doing business in Virginia, we oppose the legislation.
All right. Thank you very much. Senator McDougall. It's been moved and seconded the bill be passed by indefinitely. Clerk will open the roll.
Ayes 10, noes 5.
All right. We have 618.
Can I have a substitute on this one?
All right, Senator Stewart moves, Senator Howell seconds the adoption of substitute. All in favor of adopting that signify by saying aye. All opposed, the substitute's before us.
So, Mr. Chairman, this legislation and the substitute are designed to simplify the admission of testimony from government people who have expert testimony in civil cases. Just the two offices it applies to is OCME, the medical examiner, and the Department of Forensic Science. The original legislation had to do with limiting the fees that OCME and DFS could charge to private litigants, because I thought it was kind of weird that government experts would charge for their services when they did it as part of their government employment. And so,
let me ask you, does this speak to opinions that are formed in the performance of their government functions?
that was the intent. If it doesn't say that, that was the intent.
Right. And I could see, and I mean, I don't have a fundamental objection to that, but I do worry. I could certainly see a medical examiner being called to testify and being asked for opinions that go well beyond the opinions that were formed in the performance of his or her professional obligations.
Right, and they were concerned, the DFS and OCME are concerned about being called as a free expert, and I'm sensitive to that, which is why this substitute's in front of you instead of the bill as originally drafted. And so what this bill basically says is that a report prepared by DFS or OCME, so it'd be like an autopsy report or a forensics report for, like, it says somebody has drugs in their blood or that something's cocaine or something like that, is admissible in evidence if you give the other side either you have to give them notice either on the day your experts are due or before that, and the other side has a period of time to object. And if they object to the report and they want to take a deposition or they want you to bring the live person to trial, then they have to pay that expert's fees to come and explain their autopsy report or explain their DFS report. That way, if there shouldn't be a dispute about an autopsy report or whether something's, cocaine or marijuana or whatever it might be in a civil case.
Well, I mean, what about that? I mean, I have some sympathy for your position, but not entirely. I mean, I can see a situation, I'm looking at another trial lawyer right now who I suspect is thinking similar things. I mean, you may want to put an autopsy report in and may want to put it in for a couple of purposes, and I am on the other side of the case, and I go, well, dang, as a strategic matter, knock yourself out. I'll let you, put that medical examiner on to get those things in, because there are three other things I want to get in from that report. And if you don't put them on, I may not be able to cross-examine them, may not be able to hit those issues. Why should I have to pay if it's to help prove your case?
Well, if it's in a report, then either side could offer the report, and the report would be in evidence. It's only the issue of whether you want the live testimony to supplement it as to whether or not somebody'd have to pay or not.
Who doesn't want the live testimony?
Sometimes you might not want a live testimony about cause of death or.
If the live testimony would hurt you more than it helps you.
Mr. Chairman?
Sir McDougal.
And the other part I have a real problem with is on lines 28, I guess it starts on 27 through 30. So if you object to that report coming in because it doesn't tell the full story and you need to ask the person that prepared it specific questions, now you got to pay. So you get penalized for objecting to something that they wouldn't be able to get in otherwise. And that's just structurally not how we set up our system.
Now, I don't like the idea of getting charged by the state government for testimony that's going to be, that was developed in the course of the performance of their professional obligations. But I do worry about this structure that you're setting up.
Right. Well, I would say to the chairman is that I had that same unhappiness about, why should you have to pay, I forget what the charges are, but it's not cheap for a state employee to come and say what they did and what they found just because it's in a court. The problem is if you put a complete ban in, then all of a sudden you open the door to a lot of people trying to use our state employees as free experts, which I think is, I wouldn't want to open that door either. And so right now you have a situation where there can be fights about whether or not somebody will have to pay for a state employee to come or not for them to do their job as a state employee. And that, to me, is a policy issue that's problematic, which I think you've said too. I'm trying to solve it here, and this is what I came up with after working with OCME and DFS about it.
They support this?
The way it's drafted, they're okay with it, I think. They didn't like the original one, I think. Yeah.
I wonder, okay. Senator Stewart.
Mr. Chairman, I asked Senator Serval, isn't the answer to your problem to work something out with opposing counsel and stipulate to the matter that you want to get in without having to go this route?
Sure, that can be one way, but I've had many opposing counsel that aren't so friendly.
I wonder how the trial lawyers would feel if the defense lawyers said, I want to put this medical examiner's report in. I got some stuff on here, and a trial lawyer says, no, but for the reasons I articulated before, and then they get stuck with the cost. Whether they like that.
They looked at it, and I don't believe they don't have a problem with the bill.
They considered that possibility? Okay.
Mr. Chairman.
Sir Pete.
Yeah. And a question to the patron. In a lot of local areas, in the medical examiner, the person who does the death certificate pronounces death. And ours isn't a regular doctor? Nope.
No, the death certificate, death certificates are usually done by an attending doctor in a hospital if it's done in a hospital, but if it's an unattended death, then I think sometimes you get medical examiner.
So if the wrongful death cases I've had, and I hadn't had one last year, but there's a local doctor who comes in, issues a death certificate, and might say, what he thinks the cause of death is if he's done an autopsy. Or sometimes doesn't do an autopsy and still indicates what he thinks the cause of death is and hasn't done an autopsy. And he's a doctor. And so would this bill allow you to bring him in to testify, give that opinion without paying him?
For a private doctor?
Yes, but it's a certificate of death.
No, this only applies to a forensic report issued by the Department of Forensic Science or a report made by the chief medical examiner.
What's an autopsy report?
Or any other medical examiner.
Mr. Chair, yes, excuse me. Yeah, what is an autopsy report? Autopsies done, Mr. Chairman, Mr. Patron, aren't autopsies done at the local hospital by the local doctor who then fills out the report?
I don't think they're always done that way.
But
Maybe in Lynchburg they are. But
And then wouldn't this bill allow you to bring him in, testify what he found in his autopsy without paying him? And he's missing time out from his private practice.
I didn't think this had anything to do with private doctors. I understand you think it might, the way it reads, but I
If you're talking about autopsy,
Those
you're
of
talking
us
about an
from
autopsy report.
Rova.
Mr. Chairman.
We have private doctors who do perform that.
Mr. Chairman, this bill only
Counsel.
speaks to employees of the Department of Forensic Science or of the Department of the Chief Medical Examiner.
His assistants or any other medical examiner.
Mr. Chairman, the report on line 16 has to be duly attested by the chief medical examiner or an assistant chief medical examiner as well.
Okay. All right. Any other questions of Patron? All right, let's hear from those who are in support of this bill.
Good afternoon. I'm Amy Curtis, Mr. Chairman. I'm with the Department of Forensic Science. I'm counsel for the department. We do support this bill. We appreciate Senator Surville working with us as the bill was originally introduced. It caused the department concern. We are very cognizant of the time that our examiners spend in court and wanting them to be focused on the criminal cases and doing their laboratory analysis and not spending time in civil court unnecessarily when the reports could be admitted without their presence, and this bill does accomplish that. And we appreciate Senator Surville working with us to get that language added.
And I appreciate that, but isn't that part of the responsibility? I mean, we have civil and criminal justice system. I mean, isn't that part of their job to testify if called, if subpoenaed?
Sir, the thought process was that, and the policy has been in place with the department for many years, to charge for that testimony, to try, because the reports can come in under 8.01.390. It's a government record, and as long as the custodian authenticates them, those reports can be introduced. It's simply trying to reduce the amount of time that an examiner might be in simply to get a report introduced into evidence. And really, I've had no problems with civil attorneys understanding why we charge the fees and being supportive of that. It's not been a problem. Usually, they're able to reach stipulations, and it avoids having our people having to go to court.
So if it's worked well, why do you support this?
We support the bill is substituted. Certainly had some concerns about the language as it was originally introduced to prohibit us from being able to charge.
So you like this better than the bill as originally introduced, but do you like it better than the current system?
I think it would encourage parties to reach stipulations.
Okay, thanks.
Mr. Chairman and members of the committee, Elliot Buckner for the Virginia Trial Lawyers. We do support this bill. We had some concerns initially that there was a cost shift at the end that might look like a loser pay, but that's really not what it is. It doesn't make any significant change over what exists now. There are a number of statutes already on the books that let us do something very similar to this. 801.390.2, that covers reports by the chief medical examiner and allows them to be admissible in civil cases. 801.44.5, that's DFS reports and DUI punitive cases. 18.2, 268.7, blood tests. 18.2, 268.9, breath tests. So we can already utilize these reports in many cases. I think this makes it very clear that any facts or opinions contained in those reports are admissible as evidence, and that will eliminate some arguments. I think any concern about them, the other side objecting, whoever opposes it objecting, then they have to pay. I think that is the way it works now. You can utilize the report, and if they want to bring somebody in to challenge it, they can do it, and they have to pay for it. But if they want to try to block the use of the report, I think there should be a consequence to that. This should incentivize people to stipulate to facts that aren't really genuinely in dispute, and that's why we support this.
Thank you. Anybody else? All right, bills before us.
Move report.
All right, it's been requested by Finance. So report and re-refer to Committee on Finance. All right, motion is to report and re-refer. Open the roll.
Ayes 9, no 6.
All right, 620.
620. Okay, 620. This has to do with arbitration. It's pretty simple. I assume the company is aware that with some of the recent decisions that have come down from the CFPB, the Consumer Finance Protection Bureau, that they recently had tried to adopt an arbitration rule, which Congress rejected. Within 2 weeks of that, I got a flyer in the mail from my Discover card sticking in me with an arbitration provision in my credit card agreement. And I suspect everybody in this room probably got them also, though probably nobody read them. But arbitration is on the rise. It's out there. They're sticking it in every contract for just about every transaction you do as a consumer. And all this bill says is that if a lawsuit's filed and a judge denies a request to send something into arbitration, that cannot be appealed to an appellate court until the case is over, like any other issue. I think right now you can take an interlocutory appeal. It's one of the few things you can take an interlocutory appeal on is a denial of arbitration. And in Virginia, we have a strong preference towards only appealing final orders. And this is one of the few things the federal government has not preempted. I think we ought to take control of it, exert our states' rights, and prohibit denials of arbitration until the case is over.
Mr. Chair.
All right, Senator Peterson.
Okay, I've actually had an interlocutory appeal taken against me, and it was successful, so I may be the one guy. Scott, what happens, though, if there's arbitration is raised as an issue, you beat it at the trial court level, you go and get a multi-million-dollar jury verdict, and then it goes up on that issue, and then you get vacated?
Yep, that could happen.
Yeah, that would suck.
Yeah.
Yeah. And
it would.
I would say also, I mean, if I'm going to lose a case, I'd just soon lose it early.
I agree with that.
Looking for a response, or?
Yes.
I mean,
Isn't that so?
No, I mean, it would, and that's the theoretical possibility. And of course, what this bill would do is it'd give the plaintiff the ability to decide whether or not they want to do that in an interlocutory appeal instead of having it shoved down their throat. And so, I think that the plaintiff ought to have that choice. I don't know why the playing field ought to be tilted to say that only the defendant gets an interlocutory appeal on this, as opposed to having it like any other issue that we decide. So that's why I think we ought to at least have the option that gives the plaintiff the ability to participate in the decision about whether or not to do the interlocutory appeal. And you can assess whether or not you think you're going to lose the arbitration issue on appeal or not as part of making your decision when talking to your client about it.
All right, other questions of patron? Anybody wish to speak in favor of this bill? Anybody wish to speak in opposition to this bill? Anybody care about this bill, other than the patron?
Well, I can tell you, there's an organization that I've been working with on it and brought it to my attention. They're in D.C., American.
I thought we were talking about states'
public
rights.
justice. Public
okay.
justice.
All right, bills before us.
States' rights. That's right.
Yeah, Mr. Chair, I'm going to move to PBI, and I like most of Scott's bills. This one I don't like.
Senator Normant moves and Senator Peterson seconds the motion to pass the bill by indefinitely. Clerk will open the roll. All right. Oh. There we go. All right. Bill's passed by indefinitely. All right, next, Senator Mason, we've got Senate Bill 533.
Sir. Mr. Chairman, members of the committee, Senator Serval whispered in my ear on the way out that he has nothing to do with this bill whatsoever. He may well be supportive if it comes out of here, sir, but
we suspect he might.
He has nothing to do with this. Mr. Chairman, this is a computer trespass bill that we've seen before. It came out of the Virginia Cyber Commission in 2015, and we've been knocking it around ever since, our computer trespass statute is very difficult, and it requires malicious intent. And so, I mean, we want to make sure we don't catch anybody unnecessarily in it, but what it's led to is these crimes are very difficult to track and prosecute anyway. And so we've made it extremely difficult. So acts such as stealing information, manipulating data for financial purposes, like stealing client lists or trade secrets, are not covered under the statute.
Just hang on one second.
Yes, sir.
Am I correct? I mean, is this identical to the bill that passed out of the Courts Committee last year?
Yes, sir.
And passed out of the Senate unanimously?
Yes, sir.
And met its demise in House courts?
Funny how that happens, sir.
Yeah. Does anybody, including council, have any new issues that have come up since last year that we ought to address? Steve?
Mr. Chairman, thank you. The only thought that I had was that there may be another category of individuals for whom a caregiver might want to be able to track their movement. And so if the patron wished, what I would have suggested is that at line 49, the new language be changed to include that person, and it would read, "Nothing in this section shall be construed to prohibit the monitoring of the location of a minor, a person with a disability or mental impairment, as those terms are defined by 51.5-40.1, or the monitoring of computer usage as the bill currently reads."
Mr. Chairman, I have no
Mr.
problem.
Mason?
Mr. Benjamin, that's fine. That's far from the trouble on the other side of the chamber. I think that's fine. Yeah.
All right, is there a motion on that line amendment? It's been moved and seconded to adopt that line amendment. All in favor signify by saying aye. All opposed, the line amendment's adopted. Anybody have any questions of the patron?
Move to report.
It's been moved and seconded. The bill is meant to be reported. Clerk will open the roll.
Ayes 15, no zero.
All right, I hope you'll tell Senator Serval how nice we were to you.
Thank you, Mr. Chairman.
All right. Next, we have Senator Black, Senate Bill 71.
Thank you, Mr. Chairman. We have a substitute. Perhaps that could be distributed.
All right, Senator Norman moves, Senator Stewart seconds the adoption of substitute. All in favor signify by saying aye. Aye. All opposed, substitutes before us. Senator Black, go right ahead.
Yes, sir. We have a section of the code which lays out various means of making service on corporations. We provided, I believe it was within recent years, for substituted service on stock corporations. However, we did not address LLCs, and the fact is that most companies are LLCs rather than partnerships, C or S corporations.
Senator Black, let me just ask you, you worked with State Corporation Commission on this?
Yes, we did.
And my understanding is they have no problems with this as drafted.
That is correct.
Do
I need to say anything further?
Are you aware, is anybody here, does anybody here have any concerns about this bill? So I think it's in pretty good form.
Move to report.
Mr. Chairman,
Sarah Edwards.
What's the problem that needs to be resolved? I guess I'm missing it.
It is to conform the method of service on registered agents.
Just to give you a little bit of background, there was a process server who said, "Gosh, we love what you did on service of process, but you left out LLCs, and most companies are LLCs. And so, anyway, we work with the State Corporation Commission. They're fine with it, so I think we're
Anybody
good to go.
registered their concerns with you, Senator Black?
I have not heard any concerns over the bill.
All right, speak now, forever hold your peace if you object to this. Senator Norman.
Move to report.
It's been moved and seconded the bill be reported, or that the substitute be reported. Clerk will open the roll. All right, Senator Black, thank you very much.
Thank you, sir.
All right, next we've got Senator Reeves. Why don't we take up your bills that have lingered within the breast of the committee for the last couple of meetings? 465.
Thank you, Mr. Chairman. 465 came as a result of working with, on the Secure Commonwealth panel, on that task force I was on as a result of Charlottesville. And we found that there were some holes with regard to pointing lasers at our members of the National Guard who were called out in support of that incident. We also did some checking and found out that malicious bodily injury wasn't covered for our guardsmen as well. What this bill does is request that as our Guard are deployed in stateside mission of riots or whatever, that they are provided the same protections that law enforcement and firefighters.
Mr. Chairman.
Senator McDougal.
I'm going to move that be reported and re-referred to finance, but I'll tell you, we have no money, so.
I understand that,
This is about the
Senator.
20th bill I think our subcommittee will have received.
And I know there's somebody standing behind you. If I had to guess, my powers of observation might indicate to me that he supports this fine piece of legislation.
My agency supports it, yes, sir.
That's outstanding. Anybody here oppose this piece of legislation before we take up Senator McDougal's motion? Seeing nobody, is there a second? It's been moved and seconded. The bill be reported and re-referred to the Committee on Finance. Clerk will open the roll. All right. Next, Senate Bill 800.
Mr. Chairman, this also came as a result of some of the work I've done on the committees with regard to securing infrastructure for major
I'm sorry.
infrastructure
Let's,
within the Commonwealth. 800?
Hang on, time out.
Oh, I forgot to vote.
Can we strike the vote on,
Did you get
close it? There we go. All right, 800.
And what this bill does is codify what is already common law now by laying out in language who is liable for the trespass, for a cause of action for trespass or damage to property under that provision of law.
All right, anybody have any questions of the patron?
Mr. Chairman, I'd suggest one technical correction on line 14, changing the word during to the word by, so that there is a nexus.
By the commission? Okay.
Yes.
Mr. Chairman, that change would need to be made on line 16 as well.
I'm sorry?
On line 16, the same change would need to be made.
All right.
I would make that motion, Mr.
All right.
Chairman.
Senator Reeves moves, Senator Sturdivant seconds that, those line amendments. All in favor signify by saying aye.
Aye.
All opposed. Those amendments are adopted.
Mr. Chairman?
Senator McDougal.
Senator Reeves, what are you trying to accomplish? Right now, a court can already order restitution through any criminal proceeding, including if somebody's found guilty of trespassing. So what's the I don't think I understand the remedy we're trying to fix.
We're trying to make it clear in language, not just as you stated, Senator McDougal, that if there are those who would decide to blow up a pipeline here soon, that those group of individuals would actually be held liable for the actual cost and damage to that, and clarify that.
But if it's an act, and I know you're not an attorney, but if it's an act committed within the scope of the performance of one's duties, isn't the employer already liable under the common law of Virginia for that?
I would believe so. I don't know. I don't practice law except here in courts.
I may need to ask my lawyer, Senator Peake.
Mr. Chairman?
Sarah Edwards.
Yeah. Can somebody explain to me how this differs from the existing common law that's already on the, I mean, it's common law that you get damages for trespass.
Mr. Chairman, as I stated, I believe this is codifying common law that's there. I don't, I don't have any heartburn one way or other, Senator McDougal, on this.
Mr. Chairman,
Yes.
this codifies a portion of the common law. There are other parts of the common law that it doesn't address. For example, somebody can be liable for damages for trespass even if there is no physical damage to property, just walking onto somebody's property and they
Right.
can be liable for trespass.
Mr. Chairman, yeah,
So-
that's what, Mr. Chairman, that's what I was concerned about. Sometimes the courts interpret this as trumping the common law and limiting it as opposed to adding to it or just codifying part of it. That's a concern I have.
And I think that's a fair concern, and I understand what you're trying to do, but I kind of share Senator Edwards' concern that your good intentions may have the counterintuitive effect of rolling back the remedies for trespass or confusing courts as to the scope of their ability to remedy a trespass.
Mr. Chairman, I don't want to do harm to what is otherwise, that's, I'd make the motion, if you all are fine with it, I'm fine with it, so
I
I'd
would
strike the
suggest that
bill.
we pass the bill by for the year. Maybe you can get together with the Brain Trust over here who are looking at some civil litigation issues. I see a broad coalition sitting on the first and second row who would be more than happy to talk to you.
I'd make that motion, Mr. Chairman.
All right, second.
All right, it's been moved and seconded to pass by for the year Senate Bill 800. All in favor signify by saying aye. Aye. All opposed. That's passed by for the year. Senator Reeves, you've got Senate Bill 828.
Yes, sir. Mr. Chairman, Senate 828 is resulting of that same type of work. I am working with the administration currently with the Secretary of Homeland Security and Defense. They are going to have a couple of items that we didn't quite get in here, so I think if this bill passes, there'll be an amendment to add a few more of those, but it's pretty self-explanatory on some of the things that are covered there, such as the U.S. Department of Homeland Security Chemical Facility Anti-Terrorism Standards Program and such.
So Reeves, I think we're going to give you a little bit more time to work through some of those technical issues.
Move to report and refer to finance.
All right, it's been moved and seconded. Okay, sorry, Charles, before I, hang on one second.
I do have a technical amendment, Mr. Chairman. On lines 15 and lines 26, that $200 to be increased to $500 to go along with the felony threshold bill.
All right, Senator Stewart moves, Senator McDougal seconds those line amendments. All in favor signify by saying aye. Aye. All opposed. Those line amendments are adopted. Senator McDougal has moved to report and re-refer the Committee of Finance. Senator Norman seconds that motion. All in favor signify by saying aye or record your vote.
Thank you, Mr. Chairman.
All right, thank you. I've got a couple of witnesses here on a bill, if I can perhaps get Senator Stewart to preside for a minute. Senate Bill 526.
Senate Bill 526.
You're a third. If you've been, get it.
All right, Senate Bill 526.
Mr. Chairman, I've got a substitute that I move.
Senator Sasslaw moves the substitute. Senator McDougal seconds it. All in favor, please say aye. Aye. Substitutes before us. All right, everybody got the substitute?
All right. Mr. Chairman, members of the committee, this is a unmanned aircraft system bill, and that there are a couple of amendments that are going to need to be made to this to address some of the concerns that we've talked about. But in a nutshell, this is a very important industry in Virginia. It's growing. It is subject of considerable research being done, and enormous amounts of research dollars that are being pumped into some of our institutions of higher education across the Commonwealth of Virginia. The unmanned aircraft systems are being incorporated into virtually every segment of our economy, whether it's real estate, whether it is legal profession, whether it is just about anything you can imagine, engineering, construction industry. They are all utilizing unmanned aircraft systems, and fact of the matter is that the federal government is, quite frankly, better equipped right now to deal with some of the regulatory matters than the federal government has. Done a great deal of work in establishing a regulatory framework, and in accordance with essentially our longstanding Dillon rule here in the Commonwealth, and the need to make sure that we just don't adopt a patchwork of legislation and regulation across the Commonwealth of Virginia. This bill is introduced in order to prevent that, to make clear that state law governs, and that localities, notwithstanding their good intentions, aren't going to be permitted to step in and adopt ordinances that are going to interfere with the ability of the marketplace to continue to develop, and the federal government, and we also have the federal government regulations that are in place to protect critical infrastructure, secure facilities, and other institutions. So those are in place. I would point out that we included in this bill certain language, particularly the harassment provision starting at line 17, largely as a result of concerns that were expressed in the past by members of the House. And I suspect that our current laws dealing with harassment are adequate to address these, and I think that maybe Senator McDougall wants to make a motion to strike some language out of this, which I would second.
All right, Senator McDougall.
Mr. Chairman, I think that the bill does, in essence, I read two separate things. One, it prohibits the local subdivisions from doing that patchwork of regulation, which I very much support. The other language about the creating new penalties, I think there's a lot more to debate, and there's some positives and negatives, and I'm not sure that we have the language right here, and so I would move that comes out. I'm trying to make Senator Obenchain make sure I have it right. It starts on line 17 of your substitute. I had the lines on the old one.
17 through 22.
Should be lines.
Is that correct?
Should go through 34.
Yeah, 17 through 26.
Through 26.
Or you want to just have to?
17 through 26.
Like 27 through 34.
Okay. The 27 through 33 deals with sex offenders and protective orders, and I'd like to hold on to that at least for the time being.
Mr. Chairman, I move that we strike line 17 through 26.
Is there a second to that?
Or that, just the whole
second
section.
Okay, motion properly supported to strike those lines as identified by Senator McDougall. All in favor,
What is
please
that
say
again?
aye.
17?
Aye.
I'm sorry, did you?
17 through 26.
Okay.
I think that amendment was adopted, if I heard the ayes correctly. Any opposed, say no. Ayes have it. Okay. Mr. Benjamin, did you want to comment?
Only to add the same cautionary note that I added the other day when we had a bill that added restrictions on what a person who is required to register can and cannot do. Looking at this individually would cause, I think, little or no concern, but the cumulative effect of bill after bill adding additional restrictions on people who have already been sentenced could be challenged as effectively increasing their punishment. I note that the prohibition on line 29 is not only that a person required to register may not use a drone to follow or contact a person, it also includes capturing images of another person, which is a very broad prohibition. That's my only comment.
Okay. If there are no questions of the patron, do you have those that would like to speak?
I do.
Jay, come on up.
Mr. Chairman, members of the committee, David Skiles with the Vector Corporation representing DJI, which is a drone manufacturer. We very much appreciate Senator Obenshain bringing this bill forward. As an industry, and there are a number of folks here today to speak in favor of this bill, we have long supported the idea of uniformity of regulations dealing with unmanned systems. A patchwork of regulations that vary locality to locality could create an issue for the industry, both for commercial and consumer operations. As you all know, most of the issues dealing with unmanned systems and aviation in general are handled at the federal level. And so this legislation simply codifies what is already an existing practice in Virginia. We have a statewide preemption on unmanned regulations at the local level. There's a sunset clause on that prohibition that it expires in 2019. This would simply make it permanent. I have with me today a representative from DJI, Jenny Thibodeau, who has come down to answer any questions you may have, and I appreciate the committee's consideration of the legislation.
Hi, thank you. My name is Jenny Thibodeau. I'm Public Policy Coordinator at DJI, and I second everything that our sponsor, the chairman, said, as well as everything David has said. We're very supportive of keeping that statewide preemption, which is just a removal of a sunset clause, which is 2019. So if we can take that out from Chapter 451 from the General Assemblies of 2016, we would like to make that permanent. If you have any questions, I'm happy to take them more specific on the technology or on the bill itself.
Mr. Chairman, I have a question.
Senator Edwards.
I'm not sure. Somebody raised the issue concerning this, maybe Mr. Benjamin, intentionally, is it unlawful to intentionally follow, contact, or capture images of another person? Could somebody explain what all that means? And what the problems there are, if any?
Senator Edwards, you're talking about line 29.
Yes.
Senator Edwards,
could we let the witnesses finish first? Because I guess we could stop the clock. But let the witnesses finish, and then we can discuss that, Senator Edwards, if that's okay.
Mr. Chairman, members of the committee, thank you for having me. My name is Nathan Trail. I am from the Consumer Technology Association, which is located in Arlington, Virginia. We're a trade association that represents the technology industry. We have roughly 2,200 members, 80% of which are small businesses and startups. The rest are some of the world's best-known brands, including DJI, who you've heard from. We'd like to urge your support of this bill because it creates a harmonized and safe regulatory landscape across the state for commercial and hobbyist drone operators. Most importantly, it creates a very safe and clear, unified set of regulations for operators in the state. And for that reason, we urge your support. Thank you.
Yes, sir.
Yes, Mr. Chairman, members of the committee, Patrick Cushing with Williams Mullen on behalf of the Unmanned Systems Association of Virginia. We're a statewide association that was put together 2 years ago, stemming from the Governor's Unmanned Systems Commission report. And we support this bill. Our goal in the work that we do is in the air, land, and sea unmanned systems areas. And this is focused obviously on air. One of the things that we're looking to do is make sure that Virginia remains the best place to do business for unmanned systems. And so this bill moves that forward. Our membership, just to give you a sense of why it's important to keep statewide regulation focused with statewide implications and local regulation. If we end up with a patchwork, we've got companies that do linear surveying and linear work that cross across the boundaries of many counties and cities. You can imagine that if you were trying to inspect, for example, a transmission line or a pipeline, and you have an unmanned aerial vehicle and you're crossing over the different localities, jurisdictions, having different laws in different jurisdictions would be an impediment to that work. So I want to thank Senator Obenshain for working with us on this, and we support the bill. Thank you.
Thank you. Are there those that would like to speak in opposition? All right, seeing none. Senator Edwards, you had a question
Yeah,
about the language on
I'm not
28.
sure, maybe Mr.
Mr. Benjamin,
raised
do you want to?
a question? Is it overly broad, or what the problem is?
Well, you know, as we are limiting the ability of local governments to adopt regulations, we want to make it clear that it's not authorizing people to engage in drone stalking and harassment and behavior that none of us would condone. And we have other laws that address some of that behavior, but this is intended to make it clear that you can't do this with drones.
Any other questions of the patron? Not, the committee operates on motion. All right, motion properly supported to report the bill. Clerk, please open the roll.
Ayes 15, no zero.
Thank you.
Senator Obenchain, did you have another one?
I'll do somebody else's.
Okay.
Senator Chapin, 422.
Mr. Chairman, thank you. Senate Bill 422 is a pretty simple bill, and it's supported by the Virginia Bankers Association, but it's something that has come up in my practice quite often when you're doing a foreclosure, bank foreclosure on an unpaid mortgage, and the homeowner or the business owner, the property owner has succumbed, has passed away, and that often is why the payments are not being made, is because they've died and nobody wants to assume those payments or for whatever reason. So right now the law is silent as to how you get notice out there. So you send notice. You know, the best practice has always been to send notice to the last known address for the decedent. If you can find, if someone has qualified as administrator or executor, I send notice to them too. I do a title search, and or their heirs, if you can determine their heirs and find out where their heirs live. This legislation simply clarifies it all and takes what I think was best practice and codifies it, and says that what you'll do is you'll provide notice of the foreclosure to the address of the deceased owner and to any personal representative or heirs of the decedent that the foreclosure is going to occur. There's a technical amendment. Yes, there is.
Mr. Chairman, on line 32, after deceased, strike whose and insert who are listed on the, and then after heirs, strike is. So it would read any heirs of the deceased who are listed on the list of heirs recorded among the records.
All right, Senator Chafin moves, Senator Stewart seconds those line amendments. All in favor signify by saying aye.
Aye.
All opposed? All right, those amendments are adopted. My understanding is that notice is to be given both to the personal representative and the heirs?
Well, if there is a personal representative, you would give it to the personal representative as well as the heirs, yes.
To both?
Yes.
Okay.
You know, again, it really, I mean, if you're going to do a foreclosure, you want as many people to come as possible.
Right.
And so you want to get as many notices out to all classes of people.
All right. Anybody have any questions of the patron? Anybody in the audience wish to speak in favor of or in opposition to this bill? This bill is before us. It's been moved and saying the bill be reported. Clerk will open the roll. All right. All right.
Thank you, Mr. Chairman.
Bill is reported. Oh. Really reported.
Ayes 15, no zero.
All right. Senator Edwards, we got Senate Bill 78. Now, after 2 years, you convinced us that the Uniform Decanting Act was actually a good thing. Now you want us to change it.
It's a modest change. Decanting is taking wine and pouring it into another bottle. But in this case, it has to do with trusts. And I got some people who can explain it better than I can. Senate Bill 78.
Mr. Chairman, my name is Dan Durst. I'm a partner at Williams Mullen in the Trust and Estates Group, and I'm a member of the legislative section or committee of the Trust and Estates section of the Virginia Bar. So this amendment is a technical correction. Our prior statute, our prior decanting statute, decanting is the power of a trustee to take assets from one trust and pour them into a second irrevocable trust. Our statute that was passed in 2012 prohibited an interested trustee from exercising that power, so only a disinterested trustee could exercise the power. The Uniform Act allows all trustees to exercise the power, including interested trustees, and so this would amend the statute to preserve the prohibition that was in the prior statute, so that only a disinterested trustee can exercise the power. We think it's necessary to prevent any possible attempts at abusing the power by interested trustees, but also to prevent innocent, interested trustees from being in a situation where they could be accused of having this power.
So when you say an interested trustee, you're talking about somebody who is a beneficiary of the trust?
Yes, sir.
All right. So it's to limit the kind of self-dealing opportunity?
Yes, sir.
All right. Okay. Have other states adopted this?
So it arises because of a power that we had in our old act for a trustee to be able to grant what's called a general power of appointment, which is a power to be able to appoint assets to your own estate. That is not in the Uniform Act, and we preserved it in our version of the Uniform Act, but we didn't keep that disinterested trustee requirement.
I understand.
Yeah.
Okay. All right. Anybody have any questions? Anybody wish to speak in favor of or in opposition to this bill?
Does anybody understand it?
Kind of. Do you? All right, it's been moved and seconded that the bill be reported. Clerk will open the roll.
Can you push me?
Do you have a question about this? Hang on. You can do it. Okay.
Oh, I can? Okay.
All right. All right, that bill is reported. Next, you've got Senate Bill 159.
This has to do with the Commonwealth's lien, Medicaid lien, on settlements, personal injury type cases. Right now, it doesn't comply with federal law. There's an Alborn case out of Arkansas that requires certain standards of how you settle these liens. We have a process of going to court, but there's no go to a judge. There's no standard for him to apply. This
John,
simply tries to apply the Alborn case.
If I can, and I have great sympathy for this, and I've supported this bill in the past, I would point out that this is the same bill that was introduced last session, and I think it's been introduced a number of times before.
And it was amended last time, and yeah.
It was.
This is supposed to be the amended version.
It failed to report on a 6-6 to 1 vote last year, and I would point out that it has a rather impressive.
It'll have to go to finance.
Fiscal impact attached to it. So.
It'll have to go to finance.
Yeah. All right.
Mr. Chairman, members of the committee, Elliot Buckner for the Virginia Trial Lawyers again. We certainly appreciate Senator Edwards' persistence in this bill. It's an important one. There's a fiscal impact to it, but there's another one that you don't see there, and that's the fiscal impact to the injured people who, through the efforts of their personal representatives, through their attorneys and others, are able to collect something on their behalf just to watch it eroded and eaten away. And these are folks that oftentimes don't have an opportunity to continue working, have other medical expenses that maybe haven't been satisfied through the Virginia Medical Assistance Program, and there's a lot of hands out for that money.
Yep.
And this is not a bill that says the Commonwealth doesn't have a lien, that it's gone, that they don't get something. but that they get a pro rata share of that money, that it to be considered along with all of the other individuals and entities looking for a piece of that recovery.
Yeah, to put a fine point on it, I mean, this in real world way it could apply. Somebody could be in a crash, be a Medicaid recipient, could be a quadriplegic, have $100,000 available under insurance, and Medicaid's got a lien for well over the $100,000 that is recovered, and the court has no discretion to say you're not being compensated for your futures or for your pain and suffering, and they have to take basically all of the money, or under ERISA, all of that money.
There is nothing now that distinguishes between what portion of the recovery is attributable to medical expenses versus what portion of the recovery is attributable to lost wages, pain and suffering, or any of the other damages currently recoverable under Virginia law.
Under all circumstances, a lien is primary.
Yes.
All right.
Mr. Chair.
Senator Peterson.
This is a jobs bill, and let me explain why. What happens is that if somebody's a Virginia resident gets injured, and their injuries are covered by Medicaid, and the Medicaid bill is so high, but they come into your office and you're an attorney, and there's basically the limits, like you said, would be swallowed up by the Medicaid recovery. There's no point in pursuing the insurance company. So that out-of-state insurance company sits on that money that otherwise should be coming back to the Commonwealth of Virginia, employing people. So this is a jobs bill.
Isn't that so?
Everyone follow that?
All right. Thank you. Anybody wish to speak in opposition to this bill? All right. All right, there's a motion properly seconded to report and re-refer the bill to the Committee on Finance. Clerk will open the roll.
Ayes 12, noes 3.
All right, bill is reported and re-referred to the Committee on Finance.
Okay, my final bill today.
I thought that was your final bill today.
The final one's to be stricken from the, let me see.
It's already done. Senator Howell, Senate
you
Bill
did?
110.
You did that?
Yep.
Thanks.
Mr. Chairman, members of the committee, this is an oh my gosh, if only I'd known bill. I got a suggestion from one of the Commonwealth attorneys that I represent that we could save quite a bit of time and money and the backlog at Forensic Sciences if we did with field testing of marijuana for intent to distribute exactly like we did with simple possession. Seemed like a good idea to me. And since then, Mr. Benjamin and Senator Stewart have pointed out some of the difficulties. So I throw myself at your mercy.
So do you want to take this by for the year and maybe continue to work on
Sure,
this
that would be
concept
great.
with your Commonwealth attorney and
Yes.
with Mr. Benjamin and other interested parties?
Yes,
All right.
thank you, Mr. Chairman.
It's been moved and seconded to take this good bill by for the year. All in favor, record your vote.
It's kind of like a snake that you kill when they're young.
All right. Bill is taken by for the year. Next, Senator Chafin, you have a motion on Senate Bill 422.
And haven't voted on the prevailing side by which we reported Senate Bill 422. I'd ask that that bill be reconsidered.
All right, it's been moved and seconded to reconsider the vote by which Senate Bill 422 was reported. All in favor signify by saying aye. All opposed. That bill is reconsidered. It's before us, and the request of the patron and out of a need to work with legislative services, bill will go by for the day. Next, we have Senator Stewart. You've got Senate Bill 210.
Thank you, Mr. Chairman. Senate Bill 210 very simply extends the sunset clause from July 1, 2020 to July 1, 2023 on the State Bar Client Protection Fund. there's an assessment of bar members. I'm one of them, many here at this table actually, and that money goes to help people who have been victims of unscrupulous lawyers. And so this just extends that out for another 3 years. There are unscrupulous lawyers out there, unfortunately.
All right. Anybody have any questions of the patron? Anybody here in support of this bill?
Mr. Harris is here, but I think we're okay, Jack.
Anybody in opposition to this bill? All right. Is there a motion? Motion? Is motion a report properly seconded? Clerk will open the roll. All right. That bill is reported. Senator Lucas, Senate Bill 108.
Good afternoon, Mr. Chairman, members of the committee. Last year, the request of the Traders Association of Virginia, I introduced Senate Bill 1460, which would have permitted online advertising for tax sales of low-value property rather than requiring publication of two separate newspaper legal notices. In light of concerns expressed by the Virginia Press Association, I agreed to strike the bill and place that issue, along with several other legal notices issues, in a working group that included the Press Association, local governments, and treasurers. The bill before you, with one amendment that we need to make, that I'll discuss in just a minute, reflects the recommendation of that working group. There is, I think, peace in the valley. And kumbaya, and Alan, you would know better than anybody else. The bill would permit only one rather than two legal notices insertions when the property in question is assessed at $50,000 or less. That is, it reduces the cost of advertising a low-value property, a parcel, by half, which is significant, but does not eliminate newspaper publications altogether. I provided an amendment to council. It removes the second sentence of proposed new language that starts in line 17. The sentence that starts notwithstanding. Albert is here to respond to any questions you may have, Mr. Chairman.
Kristen, you have an amendment?
Mr. Chairman, on line 17, strike notwithstanding through parties on line 20.
So now the bill is very simple. It simply says if property is assessed at $50,000 or less, an order needs to be published not more than once.
That is correct, sir.
So, and I appreciate the need to reduce the financial burden on local governments, but is this taking adequate steps to make sure that the property owner's interests are protected?
That is my understanding, but again.
I mean, there are two reasons for the publication. One is to, I guess if you're going to auction it, you want bidders, but it's to let those property owners know that their property or the property that belonged to, Uncle Jim or Uncle Bob is being seized, right?
Well, it's not seized. This is a judicial process,
right.
Of course, Senator, and notice is already required under this, under the general statute to the property owner, to any lien holder, even a judgment lien holder, something like that. It's actually a very formal process. Once upon a time, back in the, until about the 70s, it was a more administrative process, and we went to a full judicial process. So the problem the bill is trying to address is just that with a low-value property, the advertising costs and the attorney's fees cost more than the value of the property. And it's, what happens is blighted properties, slivers left over after condemnation, something like that, just sit fallow for years. And so really, we're very grateful to the Press Association because this is a significant step, reducing the publication requirement, but it doesn't eliminate it. So we think it's a good compromise.
Okay.
I'm not aware of any real concern about the notice issues because separate notice is required to every property holder and that sort of thing. And of course, Senator, in order to get in this posture, somebody has to have ignored their taxes for multiple years.
Yeah, or have died. I mean, say it's my estranged father's property, and you know, my only connection to the community is I get the local weekly paper, and I might not see it if it's published once, but if it's published twice, I might see it.
But of course, you know, the executor or the administrator has an affirmative duty to marshal the assets. And
that is, if it's a big enough estate for an executor to be qualified.
Exactly. And if it's a small estate as to which there are none, there's no question that those kind of problems arise. You know, property on the side of a mountain, you know, something that's unbuildable, undevelopable, that sort of thing. In my experience, Mr. Chairman, you know, treasurers bend over backwards. They are elected officials just like you. They bend over backwards to track people down. Generally speaking, these are abandoned properties.
Okay, thank you.
Thank you, Mr. Chairman, and be glad to answer any other questions members may have.
All right. Roger, you want to say something?
Roger.
Mr. Chairman, VML and VACO support this and thank the senator for bringing it. And we also appreciate the Press Association being able to give a little bit on this one.
Great. Thank you very much. Yes, ma'am.
Good afternoon, Mr. Chair, members of the committee. Amy Parent-Seibert on behalf of the Virginia Press Association. And we also appreciate working with the treasurers and everybody on this bill and really appreciate the compromise. So we hope that this will move forward with the amendment.
Y'all
So thank you.
support it?
We do. Yes, sir.
Awesome.
We do. Yes.
Okay, the bill's before us. All right, it's been moved and seconded. The bill be reported. Clerk will open the roll.
Thank you, Mr. Chairman, members of the committee. This is a good sign that if you bring a bill back long enough, it'll eventually get approved.
It's almost there. All right, Senator Stanley. Senate Bill 35.
Good afternoon, Mr. Chairman, members of the committee. Senate Bill 35 is basically bringing to the state level what is Rule 35 in the federal level. So what would allow us to do in certain areas where a person's been convicted of a certain felonies that are nonviolent, you know, like not the bad ones, and they've been sentenced, usually Rule 1:1 closes off any attempt and any hope of actually having that sentence reduced later. What we're finding is that those persons that are in jail or in prison possess information that may help in other investigations, felonious investigations, serious investigations. But there's no incentivization for them to provide testimony or evidence that may lead the Commonwealth Attorney to find more criminal activity and prosecute and obtain convictions. So this basically allows for that to occur when there's been substantial assistance. The Commonwealth's Attorney may file upon its own motion in the same way that the feds do, basically a motion for reduction of sentence to be considered by the court. What counsel has actually brought up is how we can make it more comprehensive. Right now, as it's written, it only limits to Virginia crimes. So counsel, if you'll, he's got a one-line amendment, which I agree with, which may accomplish what we're trying to do. And members of the panel, this comes from the VCJC, something they've worked on. I think it's a very good bill.
Mr. Chairman, to
I
explain.
don't carry bad bills.
To explain the amendment that I'm suggesting, that one of the most common calls that we get in the defense community is from federal agents or investigators in another state who have learned that a defendant, a Virginia defendant who has been sentenced and is now in Department of Corrections has substantially important information that could aid in a federal or another state investigation, and they want our client's cooperation. The problem is that there is nothing that the feds or another state can do for the client once they're in DOC because their sentence is final. And so the suggestion is that we add this language or any substantially similar offense in any other jurisdiction, which offense would be a felony if committed in the Commonwealth.
Add it where?
Line 18.
It would be added on line 18. You would take out the or at 16, insert a comma, and then add or in the language I just read on line 18.
Mr. Chairman,
Senator Edwards.
yeah, so this would not be an unrelated offense? It would have to be a substantially similar offense? Is that right?
Mr. Chairman, that's correct. It would have to be substantially similar to any of the crimes of violence in the bill, or any of these are primarily, I think these are all drug offenses specified in the bill. So it'd have to be an offense substantially similar to those.
All right, anybody have any questions about the proposed amendment?
Mr. Chairman,
Senator
I
Edwards.
think in the federal system, it doesn't have to be substantially similar, just substantial assistance, period, as I understand it.
Mr. Chairman, that's correct, but this seemed like a good beginning. And I do note, Mr. Chairman, that this can only take place upon motion of the attorney for the Commonwealth.
Correct.
All right.
Mr. Chairman,
And
I believe that's the same in the federal system.
Mr. Doucette, you agree?
Yes.
The Commonwealth's attorneys like the amendment?
The amendment does no harm to the bill, Mr. Chairman, and as Senator Stanley has pointed out, this is a VCJC bill. For those who are not familiar with VCJC, it's the Virginia Criminal Justice Conference. It's made up of both prosecutors and defense attorneys. We work on a consensus basis. This actually had the unanimous support of VCJC, so all the prosecutors on VCJC, all the defense attorneys, all the other folks that are on VCJC agreed that this was a good bill. This does, as pointed out, this incentivizes cooperation, because right now we get letters, not calls, but we get letters from the penitentiary saying, hey, I've got information on this murder, I've got information on this drug distribution ring. And we have to say, well, that is wonderful, that is great, thank you for being a good citizen, but we can give you nothing in exchange for your cooperation. And at that point, the cooperation ends. And this is going to allow us to go forward. As pointed out by counsel, this is a little bit limited from Rule 35B and the federal rules, but as is pointed out, it's a good beginning, and we do support this.
All right, thanks.
Mr.
Senator Stewart has a question
Thank you,
for
Mr. Chairman. Mike, do you have any concern at all that this is going to give people incentive in the jails to make up stuff, to try to get credit on their own sentences?
And of course, as pointed out, this is, that is a situation that we always have to deal with, Mr. Chairman and Senator Stewart. When it comes down to substantial assistance, one of the great things about this particular bill, unlike the federal rule, is it defines substantial assistance. Under the federal rule, there is no definition of what constitutes federal.
So what are you going to do, have a hearing before a court in open court about the substantial assistance of what this prisoner or whatever gave?
Mr. Chairman, after the substantial assistance is provided in the prosecution or whatever the case, then there's a hearing that can be held. My understanding in the federal courts, a lot of times is an agreed disposition, but there will be a hearing if there's not, regardless of whether there's agreed disposition or not an agreed disposition, as to what the reduction of the sentence might be.
Mr. Chairman,
Senator Edwards.
this, I know, is being used, it has been used for years in the federal system extensively.
Yes, sir.
And one of the problems is it is up to the prosecutor. If the defense attorney says, my guy did substantial assistance, and the U.S. Attorney's Office says, no, he didn't, that's your problem in the federal system. So here, it leaves it up to the prosecutor.
It does lead up to the prosecutor, Your Honor. Mr. Chairman, bad habits or old habits are hard to break. But, Mr. Chairman, our incentive to make that particular motion is we don't want to gain that reputation of being someone who is getting the information, but then stonewalling the person who's cooperating, because it's the next person who's going to cooperate, the next person who's going to cooperate in the investigation of particular crimes. And so that is our incentive to be fair.
Mr. Chairman. Well, and if I may, just to add on that, Senator Edwards, Mr. Chairman, Senator Edwards, it's kind of a little different, and I think you know the difference because we practice Fed and state. When you go in Fed, you sign a criminal information, it's a charge, it's sentencing guidelines, and what you're trying to do is get a deviation from that range. A lot of what Commonwealth's attorneys can do on the front end is that they can make a plea bargain based on cooperation. Here, it's when that's not happened or there was an opportunity or they found guilty after trial, where they can come back, they possess that information and actually open the door. Sure. You're not in that sentencing guideline like the feds, but open that door so that that either an agreement can be made on a later reduction, or you can argue it to the court and let the court decide. But either way, it really unlocks the door that 1:1 of the Supreme Court has locked for a long time.
All right.
Mr. Chairman, just a real quick
Sir
question.
Reeves.
It might not have any relevance, but I sit on the Sentencing Commission, and I know the judges are always worried about outside the guidelines or inside the guidelines, and they're rated and graded on that. If you have a defendant that has gone through, been sentenced by a judge, and 2 years later they come back out, and now you're going to reduce their sentence, is that going to be held against the judge's original sentencing guidelines, or are they going to be held accountable for it?
And Mr. Chairman, I really don't have a good answer to that in the sense that I'm not aware that there are going to be any sentencing guidelines that are going to be on that resentencing hearing. I would have to defer to the Sentencing Commission on that. But even if there were sentencing guidelines on that resentencing hearing, there would always be that opportunity for the judge to explain that it was a Rule 35 deviation because, or a, whatever we call this, is a deviation, and that would be an explanation that would cover that judge when he came back before this body on a reappointment hearing.
Mr. Chairman, I would just make a request that somebody link up with Meredith and that commission and let them know if this bill passes that we're going to have to make a change to that form.
Mr. Chairman, I don't think a change would be necessary because the forms are currently filled out at sentencing, and there's no requirement that a form be filled out should there be a resentencing pursuant to this.
That's right. All right. Yeah. Sir McDougall moves to report. Is there a second?
Second.
Properly seconded. Clerk will open the roll.
Can you?
Stand
Right.
vote.
That's 15-0.
181.
Thank you. Mr. Chairman, members of the committee, Senate Bill 181 is a deviation from current policy. It's a very straightforward matter. It basically repeals all of the laws that permit suspension of your driver's license for failure to pay fine. Think of it this. About 1 million Virginia drivers, 1 in 6 drivers has their license suspended right now under 462395 for unpaid court debt, not driving behavior, just a failure to be able to pay for their debt. That is fines and costs. What we're trying to do here is we're trying to end this because let me tell you, as a criminal defense attorney, I can many times what I've seen is those that are at or below the poverty level, working poor, trying to make their ends meet, trying to make child support. They get a traffic fine, they can't pay it within the time allotted. Their license is automatically suspended. They're given notice, and now it's they've got to pay the reinstatement fees, or the fines start building up, or they send it to one of those law firms and the collection and all of that stuff, and they start digging a hole for themselves. That local officer, I can tell you in our areas, they know that he's got a suspended license. He waits at the end of the driveway. I've had them do this. Waits at the end of the road for my client, picks him off on his way. Pretty soon the guy's got 3 of them. And now we're extending that license suspension even further out, digging a bigger hole, a bigger amount of money. We're talking about now the child support goes down. He's pulling some jail time. We're talking about really kind of digging holes where people don't need to. What does the guy do? I work and get caught and get charged, go to jail. I have to drive, or I quit my job and go on public assistance. What I've found and what we've found in these statistics is, think about this. Driving while licenses are suspended from non-payment of court debt only led to a sentencing of approximately 1.4 million jail days between 2011 and 2015. That's not including suspended time. That's active time. So you're talking an average of over 348,000 jail days per year. I'm not a math guy, but if you apply the basically what we say it costs to jail a person every day, that's $79, $80. If you took half of those jail days, it would be $69 million incurred by state and local costs between 2011 and 2015, or $14 million a year that we pay for housing people, putting them in jail for nothing more than their failure to pay a court fine. Now, some people, listen, I've heard, well, how are we going to collect these fines? It's going to be really impossible. Well, do not forget that the legislature already made that an unpaid fine at a certain point is a judgment. It's a perfected judgment so that collections can be had. And so those fines and costs can be collected. We're not just letting people off the hook, but what we're trying to do is make a determination here. Are we making it worse for people, and especially those, and it affects, I think, disparately, the poor and the working poor? Are we making it tough for them to break the cycle of poverty when we're creating this thing? Not their driving behavior that's getting them in trouble, not their driving behavior that's putting them in jail necessarily, just the underlying offense. It's rather that they cannot pay their fines. So this basically is, we've heard words like skinny repeal. This is a full repeal. And that's the bill, Mr. Chairman.
All right. Anybody have any questions of the patron?
Yeah, I do, Mr. Chairman.
Senator Edwards.
Yes, Senator Stanley and I talked just a little while ago. Does this, the way it's worded, do that?
Mr. Chairman, I'd answer the gentleman by saying if you go to the last lines in bold, this painstakingly goes through every code reference where the suspension for the basis of fines is done. It says on line 1175 that 462395 of the Code of Virginia is repealed.
Okay, all right, thanks.
And we made changes, did we not? And is there amendment? No. Do we need? We don't need it. Okay. All right. It's all good.
All right.
It's in good
Let's hear from the witnesses who are here. Step right up.
Thank you, Mr. Chairman, members of the committee. Christy Marrow with the Virginia Poverty Law Center to speak in strong support of the legislation. I think Senator Stanley explained very well and very completely why this is such an important bill for the low-income populations that we represent. You all should have received some statistics for your individual districts that showed that the number of people who have unpaid court debt is in every district extremely close to the number of people living in poverty. And I think that we can certainly surmise from that there's a strong connection. These are folks who can't pay their debt in the allotted initial time period, and by suspending their licenses, we're simply making it more impossible for them to pay down this debt and placing them in a situation where they have impossible choices. The only other thing I would add.
Sorry.
The only other thing I would add is to emphasize that there are a number of other good collection methods in the law already, one of which was actually put into the law after the code section that allowed for this suspension was passed, and that is in 1994. The Department of Debt Collection at the Department of Taxation was created, and it is to date, if you look at the statistics from the Compensation Board reports, the most effective means of collection. And so I would just submit to you all that this is something that actually, the law that Senator Stanley's bill is seeking to repeal would actually makes it harder for people to pay their debts. Thank you.
Christy, thank you for your advocacy. I know you've worked hard to try and raise awareness about this issue. It certainly has helped me, and the coalition you've put together has been very effective in doing that, so thank you.
Good afternoon. My name is Charles Weber. I'm an attorney in the city of Charlottesville, and I'm here to support Senator Stanley's bill here. Those who know me know that I am probably one of 5 conservative Republicans in the city of Charlottesville. When I ran for city council 4 years ago, one of my promises to the constituents was that if elected, I would ask our local representatives, Senator Deeds and Delegate Toscano, to carry a bill just like this one. I can't add much to what he has to say other than the fact that I have represented thousands of clients, not just in Charlottesville, but in all the surrounding counties, hundreds of which have been charged with nothing more than driving suspended on failure to pay fines. I've collected thousands of dollars in court-appointed fees that my clients are charged with. They have no hope of ever paying it back. This is a good bill. I think my conclusions about the current state of the law is quite possibly unconstitutional, but even if it's not, it certainly has no redeeming value. There are better ways to collect debt. It may even be counterproductive in collecting debt. So I urge you to pass this bill. Thank you.
Thank you, buddy.
Thank you. Excuse me. Charlie Schmidt, Public Policy Counsel for the ACLU. We strongly support this bill. I will point out one additional caveat. Through FOIA, we've been noticing that there are, in a lot of jurisdictions where police have the ability to do a driver's license checkpoint, not a DUI checkpoint, but a driver's license checkpoint, we're seeing clusters of these checkpoints in lower income and minority neighborhoods, and it's really disproportionately affecting people. When we get the FOIAs back and we see the charges, it is almost extensively a lot of driving unsuspended license. So folks are not only running the risk, but they're getting trapped with these checkpoints that are targeting their neighborhoods, and we really applaud the legislature to try and correct that. Thank you.
All right, thank you. Yes, sir, if you'd step up and register your support, we're out of time.
Yes, I will. My name is Dennis Sisk. I'm an attorney at McGuire Woods. We're working with the Legal Aid Justice Center on the lawsuit that's claiming that this law is unconstitutional. But I do want to say I was caught in this system. The senator who's chairing the committee is aware of this. I'm an alcoholic in recovery. I went into a period of active addiction from 2000. In 2006, I went into the Richmond Drug Court Program. I was unable to pay my court costs. I had been assessed costs for court-appointed counsel. I was in jail. I was homeless. It was pretty obvious I couldn't afford court-appointed counsel. Nobody told me those costs of the court-appointed counsel would be assessed as court costs, and if I didn't pay those in 30 days, I wouldn't be able to get my license back. I rode a bicycle for 4.5 years. I believe it would be good to repeal this law. Thank you.
Thank you. Yes, ma'am.
I'll be very brief. My name is Marie Giblin. I'm from Richmond, and I'm here to say that the Virginia Interfaith Center for Public Policy supports this bill, and thanks Senator Stanley for bringing it.
All right, thank you very much. All right, anybody else? Anybody in opposition to the bill wish to step up and be heard? All right, the bill is before us.
Mr. Chairman, I'd like to, I had a similar bill. I'd like to roll mine into his. Mine is Senate Bill 148. Now that I've heard his is much better. Mine is Senate Bill 148. It's not on the docket today, but with the permission of the committee, I'd like to roll mine into 181. Then we wouldn't have to deal with mine.
You want your bill to be rolled in and for you to be listed as a co-patron. Okay?
That's fine.
Is that all right? Okay. All right. What is your bill?
148. Mine is 148.
All right. So there's a motion to roll 148 into this bill for Senator Edwards to be listed as a co-patron and for this bill to be reported. It does not have a fiscal impact or a request from the Finance Committee.
It saves money.
Do you want to make a motion to that effect?
It's a money saver. Bringing money back to the Commonwealth
All right.
coffers.
The motion, is that's your amended motion? Okay. The amended motion is report and re-refer. Clerk will open the roll. All right. Congratulations.
Ayes 12, noes 2, abstentions 1.
I'll find out who those two are. Thank you. Thank you, Mr. Chairman.
All right. Sir Peterson, you and I can flip a coin. All right, you win. Go right ahead. Senate Bill 14. We're going to plow through these. All right.
All right. Mr. Chair, members of the committee, I'm going to start with a simple one. And I always think it's good when you can remove language from the code as opposed to adding language. And that brings me to Senate Bill 14. Senate Bill 14 deals with service of process on a county attorney. And specifically, there's a law in the books, 8.01-300, which says that when you serve process on a local government, which is to say on a local government employee, currently you have to, if the cause of action is against a supervisor, a county officer, employee, or agent of the county, arise now their official actions, then in addition to the party defendant, you have to serve each supervisor as well as the county attorney, if there is a county attorney, And if there is no county attorney, then on the clerk of the county board. I had no knowledge of this law. I filed a suit against a county employee, just sort of a standard suit that you filed, and there was a demur filed because I hadn't served a copy of the process on the 12 members of the Fairfax County Board of Supervisors, which is a complete waste of time and money. So no one's explained to me the purpose of this bill, or excuse me, the purpose of the current law, so I brought this bill to eliminate that needless red tape. That's it.
All right, anybody have any questions of the patron? Local governments have any thoughts about this?
Mr. Chairman, VML and VACO don't have any official position on this. It looks to me like you're simply conforming the procedure for counties with what's already the rule for cities. I think the only difference with cities is that maybe you serve the mayor instead of the clerk of the council, but the procedure's the same. It seems to me you should only have to serve the individual board members if you're bringing suit against them in their personal capacity. Otherwise, if you're just suing the entity or some other employee of the locality, the service on the county attorney ought to be adequate.
All right. How about Fairfax County?
So, Mr. Chairman, Chris Costa from Fairfax County. We brought this before our board. They were happy to support this bill.
Ah, okay.
Mr. Chairman, I think
Senator Stewart.
Roger brings up a good point. If you're suing them in their, would this supersede if you're suing any of them in their?
Well, you still have to,
capacity?
if the person is named a defendant, then you still have to serve them. So that part doesn't change.
I don't disagree with your bill, but I think Roger brings up a good point. If you don't want to not serve a defendant if you're suing them in their individual capacity, but they are also a board member.
This requires that.
Mr. Chair.
Right.
Okay.
This says
Right.
that if the case be against a supervisor,
Right.
then in addition to the named defendant in the case, so
Right.
if it's against the supervisor, that supervisor is a named defendant.
Right.
So in addition to that named defendant, you don't have to sue the other supervisors
Right.
Language
or
is a
serve
little
the other
awkward, but
supervisors,
right.
just the county attorney.
Right.
Okay.
Right. And just to give you, and you'll hear more about this case, and I sued a county.
Don't knock it off the
Right.
tracks. All right. It's been moved and seconded the bill be reported. Clerk will open the roll. All right, Senate Bill 17.
Okay. Senate Bill 17 is a little bit more complicated.
I'd say.
And I hope VTLA hasn't left the building because they're going to need to help me on this. Basically, this has to do with underinsured and uninsured motorist coverage. I think folks are already
Way
familiar.
behind you. Like
Okay.
not here.
Okay, all right, well, right on, General Custer. Okay, so we already have bad faith laws in Virginia, and I know there's a difference of opinion, or maybe there's not, as to how effective they are, but they don't cover this situation where you have what we call UIM coverage. So say, for example, and tragically this happens, where somebody is struck by a vehicle and they could be killed, and the motorist has no coverage. And so you are retained by the family, you bring a claim, there's no coverage on the other side, so you go against your client's own policy. And there may be 100 on it, 100,000, 300,000, usually somewhere in that ballpark. And you have all the same factors of litigation that you would have where you're making a claim on somebody else's policy. This just basically takes that whole concept and switches it to the UIM arena. The language on this bill is more complicated than it should be. And I regret that I haven't had time to kind of rewrite it and put it in more plain English. But the plain English is this: if there is what's determined by the court to be basically an unreasonable refusal to make a settlement, then within a prompt period of time, and again, this would be something that would have to be litigated in a post-trial motion, just the same as it would be in a bad faith claim, that would be something that would be decided by the trier of fact afterwards. And let me give you the same example. Let's say you had a wrongful death case, and your client is killed, you represent the family, there's no insurance on the person that drove the vehicle, you then bring a claim under their UIM coverage. Let's say there's 100,000 on the policy. They don't put the limits up, you got to go hire experts, you got to go prove the case, and let's say liability is undisputed. You got to then go put on a grief counselor. You got to go through the whole thing, get a jury verdict for $2 million so you can collect $100,000. That would be the type of case that where the limit should have been posted, and I think you could bring a motion under that.
Chap,
Yes.
let me tell you what my concern is about this, and I'm with you in spirit, but for the first party bad faith claims, you have to simply prove bad faith. You don't have to prove that the settlement settlement offer was in a reasonable amount. Isn't this creating additional issues that don't exist in a regular bad faith claim?
Well, I think it's still the same thing. A bad faith claim was the demand or was the claim treated
In bad faith.
in bad faith? Did they deny it? For example, were liabilities undisputed?
Here you've got the question of, was it in a reasonable amount and was it in bad faith?
And I think, quite honestly, again, if I'd had more time, I would have truncated the language down a little bit more on this.
You need more time?
Do you mind giving me an extra week on this?
Well, that wasn't what I had in mind.
Well, I don't want folks out there, families to not get a recovery just because I didn't do a better job of drafting this, but.
And I think there's something to be done, and I would say that over the last couple of years, we've been tinkering with the underinsured motorist coverage issue and trying to incent uninsured motorist carriers to come to the table to participate in negotiations. And my recollection was that the last effort was only effective as of policies issued January 1 of 2016. So I'm a little concerned that we haven't given that an opportunity to play out. I absolutely agree that there's an issue that needs to be addressed. And my inclination would be to maybe wait until next year, get a year of experience, and see if this remains an issue. But it's the committee's decision.
Okay, and I'm happy to answer any questions. Like I said, it looks like I'm on an island
All right,
up here.
Jim. Is there anybody you want to speak in favor of it before I hear a motion being whispered in my ear? Senator Stewart.
Mr. Chairman, Chap.
Yes, sir.
You want to work on this over the course of the year? And
Yeah,
see what happened
I didn't
with
realize
the change?
VTLA ran for the hallway. So, if it's the will of the committee to take it by a year, I do have a coalition of attorneys in Northern Virginia I was working with, and like I said, I do want to shorten up the language. So.
And I'd be happy to work with you on that.
All right, fair enough.
All right, Senator Stewart moves, Senator Peak seconds that the bill be carried over for the year. All in favor signify by saying aye. All opposed, the bill is carried over for the year. Next bill is?
I think the next two are going to be uncontested. Well, Senate Bill 272, I've got representing the subcontractors. I think according to the folks I'm talking to, they need one more week to work that out with the General Contractors Alliance. And so if I could get one more week on that, I think we will have peace in the valley on that.
All right, since the last one was carried over for the year, I guess
this will be 1 week.
We'll accede without objection to your request that Senate Bill 272 go by for the week. Next, Senate Bill 280.
Senate Bill 280, as I understand it, I'm repeating what was told to me by folks in the, I believe in the Poverty Law Center. There was a similar bill carried by Senator Locke in general laws, which got referred to the Housing Commission. So I don't know if you all wanted to refer this to the Housing Commission or refer this to general laws, but for some reason these bills were sent into different committees. It really should have been in general laws.
Yeah, I think that's an outstanding suggestion that we refer this to the Housing Commission. So we'll, Senator Stewart moves that we carry this by for the year with a PBI with a letter to the Housing Commission is Senator Stewart's motion.
Okay. Can I get yes, sir.
All in favor of passing the bill by indefinitely with a letter to the Housing Commission signify by saying aye. Aye. All opposed? That's done.
All right. Senate Bill 895. punitive damages. We've had a punitive damages cap of $350,000 from 1988. I don't need to tell you that the value of the dollar has changed significantly since 1988. Obviously, we've dealt through this to the felony threshold. I'll give you an example of why the current law.
If I can,
Yeah.
maybe to help you, I mean,
Sure.
this passed out of this committee fairly overwhelmingly last year.
Sure.
With a $500 increase, $500,000 cap.
That's fine.
It was set in 1987 at $350,000, hadn't been modified since. And I don't know whether it'd be the will of the committee to do what it did last year, but maybe it is. You want to make that motion to amend to 500?
I'll make that motion myself to amend to 500.
All right, it's been moved and seconded to amend to $500,000. Anybody wish to speak in favor of the amended bill to increase the cap to $500,000? Yes, sir.
Mr. Chairman, good afternoon. My name is Mark Dixon. I'm here on behalf of the Virginia Trial Lawyers Association. We support the bill as amended. Of course, VTLA's position is there shouldn't be any cap on punitive damages considering what they're intended for. And the $350,000 that's currently on the books has been there since 1987. While we'd like to see no cap, we believe this is a step in the right direction and we support the bill. Thank you.
All right. Anybody else? Anybody wish to speak in opposition to the bill?
Mr. Chairman, members of the committee, Jeff Palmer with Reed Smith on behalf of the Virginia Chamber Institute for Legal and Regulatory Reform. We are opposed to the legislation. We feel like it will make litigation more expensive in Virginia, make it more costlier to do business, could have a negative impact on Virginia's business rankings. As everyone knows, the compensatory damages are designed to make the plaintiff whole. Punitive damages are designed to punish the defendant, and I don't think that the inflationary arguments don't apply as well on the punitive side of things. I don't think there has been arguments that.
Does
Yes,
the
sir.
chamber favor just getting rid of punitive damages altogether?
No,
Do you believe that they have no role?
I think the level that's been in place for a number of years is appropriate to continue from our perspective.
All right.
Thank you.
I understand. Thank you. Anybody else wish to speak in opposition to the bill? All right, bill is before us. Senator Peterson, you have a motion?
I'll make a move to report.
Second.
All right, it's been moved to and seconded to report the bill is amended. Clerk will open the roll. You can vote up there.
Yeah, let's see, did these vote?
I got
Ayes 11, noes 4.
I have one more, which is 904, Mr. Chair. That's a line of duty act. And I really,
finance.
Yeah, that's what I thought. Okay.
Mr. Chairman, I think these are the last two bills on the docket today. That's great. Thank you. 535 is we adopted a law a couple of years ago that requires insurers to disclose their policy limits in the event of a serious injury with medical expenses exceeding $12,500. We want to make sure that it's not a frivolous claim. What this does is it also requires insurers to extend or to inform of their policy limits in the event that the defendant has been convicted of DUI and that evidence is provided to the insurance carrier. Simple as that.
Is that after an appeal or prior to? Or do you care?
I don't believe, well, it says regardless of the amount of losses, if the alleged tortfeasor was convicted of an offense under the DUI statutes and the person's injuries arose from the same incident that resulted in the conviction. My understanding is that you're not convicted if it's not final. So if you're on appeal, my view would be that it's not a conviction.
Is that
And
accurate,
I
Mr.
would,
Benjamin? If you're convicted in general district court and you note an appeal in circuit court, are you not convicted?
I don't know.
Actually, that is correct with general district to circuit court because an appeal vacates the conviction in general district court.
That's, Mr. Chair.
Okay.
Mr. Chair.
Senator
Mr.
Pete.
Yeah, it's general district appeal not, but from circuit court to court of appeals, you are.
How about a final judgment of conviction?
Yeah.
The final judgment is entered at circuit court, and that remains a judgment of conviction until and unless it is reversed or vacated by an appellate court.
How about if we add language saying in the time for any appeal, and no appeal has been taken, or the time for appeal has expired?
That concept would work.
Does that solve that problem?
I think
I would
so.
move that amendment.
Okay, is there a second to that amendment? All right. Motion properly seconded to amend it as described by the patron. All in favor, please say aye. Aye. Opposed, no. The ayes have it. Okay, any questions of the patron? If not, what's the pleasure of the committee?
Move report.
Oh, I'm sorry. Is there anyone who's in opposition to this? It's late, so we're moving along. Okay, motion to report the bill properly seconded. Clerk, please open the roll. All right.
Ayes 14, noes 1.
Report's almost unanimously. What's your next bill?
Last bill is Senate Bill 536. And
Senate Bill
I think
536.
we have a substitute, which I move the adoption of.
Okay, Senator Howell moves the substitute. Senator Stanley seconds. All in favor, please say aye. Aye. Opposed, no. The ayes have it. The substitute is before us.
And, Mr. Chairman, let me tell you the situation that gives rise to this bill. And I also want to thank the Hospital and Healthcare Association for working with me to, I think, eliminate concerns that they expressed. And I don't know that they support this, but I think that we've gone a long way towards addressing their concerns. Here's the problem. You know, we have a statute that says that if you have a third-party claim for injuries, you're the hospital, and you have health insurance, the hospital has to bill your health insurance. They can't just say, I'm going to bill you, and because some third party is going to ultimately be responsible and ding you and dun you and report it to your credit bureau and ruin your credit. I bought health insurance and they bill it, and quite frankly, what happens is you get the benefit of that bargain as well, in that they pay the contractual rate to the carrier or to the healthcare provider, and you get the benefit of that. We have older Virginians who are covered by Medicare, and it's virtually the identical situation. But there are some hospitals, and not all, most hospitals go ahead and bill Medicare. And that's the way that they're supposed to do it. But some have decided, and healthcare providers, I don't mean to single out hospitals, some have said, you know, we're not going to bill them because we're not required to under the statute. And the reason is pretty clear. It's because if you don't have to bill those that third-party payor, you can continue to ask the patient to pay the top dollar, and it may be twice as much or even 3 times as much as would be paid. And that person is going to be personally on the line, and it's the, you know, it doesn't matter how you change the maize, the rats always find the cheese. I mean, it is a way to maximize the recovery that they get. And this simply conforms the law and says no matter who the third-party payor is, if they're permitted by state and federal law, if they're not prohibited by Medicaid or Medicare federally, they're required to bill that third-party payor. And at the end of the case, the state and the federal government are held harmless anyway, because that injured person is under an obligation under state or federal law to repay the benefits that were paid by the federal or state government under Medicaid or Medicare. So this is protecting people's credit, making sure that to the extent possible, those healthcare providers are getting prompt payment, and that people who are injured and don't have the ability to pay these bills are getting these bills paid in a timely fashion. And if a third party is ultimately held responsible, you know, the Medicaid or Medicare are going to be held harmless and going to be repaid anyway.
Okay. Any questions of the patron? Does this need to go to finance? Are you aware?
No.
I'm not. Is there anyone who's in opposition to this? Motion properly seconded to report the bill. Clerk, please open the roll.
Thank you.
That's 15-0.
Oh, I'm sorry. I do have one that I think Steve may have a suggestion or two for, and I don't know whether we want to do this today. Do you?
We can do it today.
Okay. Well, let me do Senate Bill 563.
Senate Bill 563.
Right now, it's against law to create any image of any non-consenting person in a state of undress or taking a picture, you know, upskirt or something like that. This bill deals with incapacitated adults, and what it's not supposed to deal with is necessarily not intended to capture drunk adults. That's supposed to be captured under the rest of the existing law, but this is dealing with people in nursing homes, older adults, folks who are incapacitated because of physical disability or age, and it arises out of a situation in a nursing home in Shenandoah County, and this was brought to me by the Commonwealth's attorney for Shenandoah County, who wanted this provision to protect these senior citizens, these residents of nursing homes, from being victimized in this really sick and disgusting kind of way. This does elevate this to a felony in the event that a violation of this occurs with respect to these incapacitated adults. So if it's the pleasure of the committee to report this bill, it needs to go to finance, and I think Steve has a suggestion for how to correct the excessive breadth.
That's correct. That's correct, Mr. Chairman. And what we're doing is just substituting a different definition. And so on line 47, after the word "is," you would insert this language: a person with a disability or mental impairment, as those terms are defined in section 51.5-40.1. Similarly, on lines 30 and 32, instead of we would substitute for the language that's in the bill, this language: a violation of subsection A shall be punishable as a Class 6 felony if the person depicted is a person with a disability or mental impairment, as those terms are defined in 51.5-40.1.
And just because I'm curious, what is 50-5, 40-1?
Mental impairment under that section, Mr. Chairman, means a disability attributable to intellectual disability, autism, or any other neurologically handicapping condition closely related to intellectual disability and requiring treatment similar, and it goes on. And then person with a disability means any person who has a physical or mental impairment that substantially limits one or more of his major life activities, or who has a record of such impairment.
Okay, so it's a little broader than your definition, but it certainly would include folks in a nursing home with dementia or Alzheimer's or something
Certainly.
like that.
And what it does not do is include somebody who's simply intoxicated, and then there's a photograph of them.
Okay. All right, is there a motion on that amendment?
Second.
All right, motion properly seconded to amend it as described by Mr. Benjamin. All in favor, please say aye. Aye. Opposed, no. The ayes have it. Any questions of the patron? Anyone who is in opposition to this? If not, is there a motion?
We refer to finance.
And re-refer to Senate Finance. Motion to report the bill and re-refer to Senate Finance. Clerk, please open the roll. All right, that bill reports as well, Senator Obenshain.
Okay. Did you say
That
I have
it?
another? That was going to request that that go by for the day. Is that okay?
We finished?
How many bills have we gone through? 75 bills left out of 220-ish. So we've done a good many bills.
Okay.